I'm going to start setting up to get ready to, we're going to read through this whole thing because I think this is probably very important. Somebody donated $10 earlier and said, any advice for dealing with everything? I'm watching my country be destroyed and my friends who were never political before a year or so ago are cheering for it. It keeps getting worse. I don't know. Political stuff is like stuff that you engage with once your own personal stuff is a little bit more settled and stable. If you feel a bunch of discomfort in your personal life, or if following this stuff provides for a lot of discomfort or is making you feel bad, then you shouldn't be engaging with it. It's not good for you. It's not healthy.
So we don't need to talk about where I saw this because, I don't know, we don't need to like dump attention on people with bad takes. But I recently saw a person talking about how environmentalists were hypocritical because pipelines, oil and gas pipelines, are actually good for the environment. And if you look at this through a very narrow lens, there's like a truth here, which is that moving oil through a pipeline is far more efficient than moving it on a train, which is how you would typically otherwise be moving that oil around. But there is a thing where right now, oil is pumped out of the ground, put into trains, and then the trains drive to the refineries. And on the way to the refinery, that produces a ton of carbon emissions. So it would be way more efficient per unit of oil delivered if we just put it in a pipeline. So why are these environmentalists hypocrites?
Are we going to use the term induced demand? Cheaper oil increases demand for it, so overall pollution goes up, even if it's better to transport it that way because it's cheaper and now people are using more of it? What are we thinking?
Blocking pipelines. About 20% of the total like CO2 that fuel, that like gasoline is responsible for, is emitted before it gets burned. So in the process of distributing it to like from the refineries to the gas stations, in the process of refining it, which produces carbon dioxide, in the process of producing it, getting it out of the ground, and in the process of getting it to the refineries. So getting it to the refinery more efficiently would be better for the environment, right? So why don't we like pipelines if they're better for the environment, if they lower the carbon footprint of gasoline? And the answer is pretty clear. That infrastructure pays for itself on the scale of decades. And so if you are building new pipelines, what you are saying is we're going to be using this pipeline for decades. And we can't be doing that. We cannot be using a pipeline that we build today, 20 years from now, because 20 years from now, we cannot be burning gasoline anymore. We can't be doing it for our lungs. We can't be doing it for our climate. We can't be doing it for our wallets. I think that there is some legitimacy to separating the sort of climate movement, whatever that is, from the problem of climate change and how we are going to solve it. I think there is a certain amount of the climate movement that encourages hopelessness, that is very doomer, that kind of pitches things in binaries that I think ultimately end up harming our progress. So if you're constantly telling people that like this is the tipping point and after this tipping point then there's nothing we can do, then that's like you're breaking the process, because of course when we hit the tipping point and the world still exists and you're still telling people that we still have to fight, should I be hopeless? Should I not believe you anymore? What's the truth here? And there is some tension between like portraying the complex reality of energy transition and motivating people to climate action or to just care about this topic. And I'm not entirely sure how to balance those things. And I don't think that like anybody decides how to balance them. I think that this is largely out of people's control. It's a bunch of individuals acting in their own ways, how like in the ways that they feel best to act in and that they like the most. There are many, many times when building a pipeline means now you can drill for oil that you previously couldn't drill for. So it has become, because of the pipeline, not just economically available oil, it has become economically imperative oil. We have to drill it to pay for the loan that we took out to build the pipeline. And part of me like, okay, if I think that people can be swayed by like a little stupid argument like that to be like, I guess climate change isn't real, then, but I kind of think that we have to do everything we can to reach everyone we can. And so if there is this little meme going around that's like, oh, I don't believe it. It turns out that the climate activists actually made it worse. No, they made it better. They made it better because that oil that previously would have got pumped out of the ground because it suddenly would have been more economically efficient and helped pay for this pipeline, that stayed in the ground. That stayed in the ground. It didn't get shipped more inefficiently. It never got taken out of the ground in the first place. That's why we can't build new pipelines. That's why pipelines are over. And every time anyone wants to build a new pipeline, I am opposed to it. Because if you can't make money putting it on a train or a truck or whatever, then that oil is going to stay in the ground. And that percentage of its carbon impact that would be negated by putting it in a pipeline rather than a train is peanuts compared to just leaving it in the ground. We have alternatives now. And 20 years from now, there are going to be a lot of other options. And I'm confident that all of them are going to be cheaper than gasoline, which is not getting easier to get. So we need to make this transition. And anything that smooths our path in making it.
Okay, I don't care about this. Okay, and there you go. Set up. Wait, real quick. What is this? The 100 best movies of the 21st century. Super bad. Yes. Should be higher up, but we take that. Memoirs of Murder. Don't care. Grizzly Man. Pff, this guy, we just learned about him. Don't care. Gravity. Eh. I didn't watch it. I heard it was meh. Black Panther. Yes! Cape shit in my top 100 list! The Worst Person in the World. Didn't watch. No opinion. Minority Report. That was 2002? Hell the fuck yeah. Michael Clayton. George Clooney is always cool, so sure. Haven't watched it. Gladiator. Okay. Fish Tank. Didn't watch. Francis Ha. Don't know. Don't care. Interstellar. Okay. Yeah. Okay, what is number 1? That's all I care about. Eternal Sunshine of the Spotless Mind. That's 7. Wow, this guy must have been feeling a certain type of way when he made this list. No Country for Old Men. It's a good movie. 6, though? Okay. Moonlight. Didn't watch it. In the Mood for Love. I haven't seen it. There Will Be Blood. This is a very good movie. Mulholland Drive. Haven't seen it. Looks cringe. Looks old. 2001. And oh my god, get me the fuck out of here. Oh my god. Get me out. Get me out! Get me out of here! Okay. Trying to remember how we did this. We opened this program. Get out of here. Go to this. Nope. Bro, file navigation on Apple anything is just, it's actually a fucking nightmare. I don't even know half the time if I'm actually editing or looking at the actual file, or if it's like the 5th copy that's been made for some other program folder or whatever the fuck else. Oh my god. Oh my fucking god. What is this? No clue. I don't know how to... I don't even know how to add connection. What am I adding a connection to? Cloud storage, network connection. What if I just want to look at the folder where my Obsidian stores files at? Is that impossible? Am I not allowed to do that? Is it impossible? I can't do that? Is that just not a thing you can do? Oh, hold on. If we click Files, Recents, don't know where that information is pulled from at all. What about Shared? Nope. Recently used? Chrome? Nope. Oh, what about this thing? On my iPad. Oh my god. Hold on. Hold on. Jesus. Oh my god, PDF Expert has AI now? Oh, AI powered PDF Copilot. Oh my god. I've been waiting for this for so long. Thank God. Thank you. Thank you. Thank you, God. Finally. Finally. Okay. What fucking program did I use to put... Oh, it was OBS, right? And then iPad? The fuck is this? Oh, it's NDI, I bet. That's what it is. Okay. Do you think if I just turn it on here, it's just going to work instantly, right? Oh my god, it did work. Wait. Wait. Okay. There we go. Okay. So we're gonna do my final TikTok stream reading this stuff. Okay, boom, boom. Alright, the fuck is this? People keep linking this. Hold on.
I don't know. NMP kind of gives me kind of like weirdo vibes. He kind of gives off the vibes of like
I think he's a plus guy.
Yeah, well he gives off.
Reacted to your clip, but then Judy was like, "Oh, show us the."
But like no shade or no like, you know, gives off the hey, I have followers kind of vibe, and then I'm gonna, you know, yeah, we can stream together, but also I'm gonna try to like hit on you afterwards and then try to make you sleep with me kind of vibe, and then like if you say no, I'm gonna like force myself on you kind of vibe. This is just what I get.
Jesus.
I don't know. NMP kind of gives me kind of
Rape vibes. Okay. No shade, though. Seems like a rapist, but no shade. This. This. Okay. And then we do TikTok. Do you think they'll be able to hear me if I just like speak and I don't have my AirPods in? Probably. Dude, I can't do phones. I'm a fucking boomer. Okay. Live? Okay. Reading. Trump v. Casa. Supreme Court decision. Oh, can't have that many characters. Okay. Add topic. What is the topic? Can I do politics? Is that even a thing? Music, beauty and fashion, fitness and sports, learn, live match, food, gaming, pop culture, fandom, chat and interview, animals and pets, outdoors, daily life, do-it-yourself, art, dance, relations. I guess learn? We're learning, right? It's kind of like learning. Scaled live rewards. Collect diamonds from... Okay, add a live goal. Do I need a live goal? They gamify the fuck out of this. Holy shit. I don't need any of this shit. I don't care. Stop! Quit editing. Quit. What is the ruling about? I don't actually really know that much. So we're just gonna fuck it. But it's a long-ass read, so I'm sure all of that will be made apparent. No. Where's the little... Okay. Do this. No? Hello? Wait. Push. Wait. This? No? This? No? This. Wait. No. There we go. No. Why is it not? Why are we not doing it? Oh, no. Oh, wait, I bet. There we go. What about now? There we go. Cool. Good job. I'm so proud of you. King. Okay, hopefully after this TikTok thing, I can go live on my own. Go live. Please don't kill my stream for no reason. Why does this feel like it's tilted? Oh, don't know, don't care. All right. I don't know if you can hear me on TikTok. Don't care. I need to stream for some amount of time, and I'm reading Supreme Court case. Good luck. Wait. No? Fuck. Stop. I mean, shoot. This. Okay. You can see this? All right. Supreme Court of the United States. That's our top level federal court for the U.S. government. This is the syllabus. No, and my TikTok stream ends for no reason. Okay, we'll just start talking. Never mind. But good luck. Where it is feasible, a syllabus or head note will be released, as is being done in connection with this case. At the time the opinion is issued, the syllabus constitutes no part of the opinion of the court, but has been prepared by the reporter of decisions for the convenience of the reader. So if you're not used to reading Supreme Court rulings, anything that's written under the syllabus is going to be like a summary of the ruling, but the syllabus is not written by any of the Supreme Court justices. It's just written by the court reporter that kind of summarizes what the ruling is. We'll read the syllabus and then we'll read the decision. This is kind of a longer one. This is like 111 pages or something, so good luck. Trump, President of the United States, et al. That means there might be other people that are parties on that side. Verse, Casa Inc. et al. There are other parties on that side. On an application for a partial stay. So I believe that a stay is where you are asking... Okay, never mind. I'm just never streaming on TikTok, I guess. Fuck this account and fuck me. The TikTok dream is dead. Okay. Trump, on application partial stay. So generally, I believe that a stay is usually where you are, asking the court to stop doing something. Like a stay is like belay that order. Stop, you want the court to stop doing something. So it's like Trump has applied for a partial stay, meaning to stop an order that a lower court has issued, I think. Plaintiffs, the respondents here, meaning that the court, the original case, it looks like was filed against Trump, but this is a separate case, an application for a partial stay. So the plaintiffs are, this is not referring to Trump here, it's referring to the other side, the defendants in the stay application, but the original filers of the underlying case. Plaintiffs, respondents here, individuals, organizations, and states filed 3 separate suits to enjoin or to legally stop the implementation and enforcement of President Trump's executive order number 14160. C, protecting the meaning and value of American citizenship. 90 Fed Regulation 8449. The executive order identifies circumstances in which a person born in the United States is not subject to the jurisdiction thereof and is thus not recognized as an American citizen. The plaintiffs allege that the executive order violates the 14th Amendment's Citizenship Clause, Section 1, and Section 201 of the Nationality Act of 1940. In each case, the district court entered a universal injunction, an injunction barring executive officials from applying the executive order to anyone, not just the plaintiffs. Has this term, I'm curious, before 2025, has this term been used before? Universal injunction. Before 2023. Supreme Court. There's been some chat about it. Okay, there's an article, at least from Harvard, about it. Although it's recent, in 2020, but okay. In each case, the district court meaning the federal court, the first federal court where these cases were heard individually, entered a universal injunction, an injunction barring executive officials from applying the executive order to anyone, not just the plaintiffs. And in each case, the Court of Appeals denied the government's request to stay the sweeping relief. The government argues that the district courts lacked equitable authority to impose universal relief and has filed 3 nearly identical emergency applications seeking partial stays to limit the preliminary injunctions to the plaintiffs in each case. The applications do not raise, and thus the court does not address, the question of whether the executive order violates the Citizenship Clause or Nationality Act. Instead, the issue the court decides is whether, under the Judiciary Act of 1789, federal courts have equitable authority to issue universal injunctions. Okay. One thing I'm curious about, were each of these underlying cases in different circuits, or do they all come from the same circuit? Trump v. Casa. SCOTUS blog, Wikipedia. Okay, 18 states and 2 cities filed a lawsuit in the district court for the District of Massachusetts, and then 4 other states filed a second lawsuit in the district court for the Western District of Washington, and a third lawsuit was filed in the district court for the District of Maryland. Circuits, Wikipedia, USA, legal. Just show me the map. Okay, Maryland, Washington is obviously way the fuck over there. And then what was the other one? I'm just checking. Massachusetts. Gotcha. Sorry. Okay. Okay. So these are 3 completely separate circuits that all ruled against Trump on this. All of them issued injunctions against this. So all right. Held. Universal injunctions. Wait. Oh no, it's telling you the holding, not that it's holding from a lower court. Sorry. Okay. Held. Universal injunctions likely exceed the equitable authority that Congress has given to federal courts. The court grants the government's applications for a partial stay of the injunctions entered below, but only to the extent that the injunctions are broader than necessary to provide complete relief to each plaintiff with standing to sue. The issue raised by these applications, whether Congress has granted federal courts authority to universally enjoin the enforcement of an executive order, plainly warrants this court's review. On multiple occasions and across administrations, the Solicitor General has asked the court to consider the propriety of this expansive remedy. The Solicitor General is like your main attorney that argues on behalf of the government in front of the Supreme Court, basically. I don't know if he does other stuff or if his job is mainly just arguing government cases to the Supreme Court. As the number of universal injunctions has increased over the years, so too has the importance of the issue. The government is likely to succeed on the merits of its claim that the district courts lacked authority to issue universal injunctions. See this, holding that for a stay application to be granted, the applicants must make a strong showing of likelihood to access the merits. The issuance of a universal injunction can be justified only as an exercise of equitable authority, yet Congress has granted federal courts no such power. The Judiciary Act of 1789 endowed federal courts with jurisdiction over all suits in equity, and still today, this statute is what authorizes the federal courts to issue equitable remedies. This court has held that the statutory grant encompasses only those sorts of equitable remedies traditionally accorded by courts of equity at our country's inception. I haven't heard this term before. Let me look up equitable authority. Also, I'm going to try something. Listen, if you have questions or comments related specifically to this, I'm mainly looking at Kick Chat and then YouTube chat for this. All right. Equitable authority, Westlaw? Fuck. I don't know how this is like defined like legally or historically or whatever. Fuck. Fuck, I feel like I want to know what this means. Equitable authority. Origin of court's equitable authority. Article 3, Section 2 of the U.S. Constitution provides, in relevant part, that the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, treaties, at the time the United States Constitution was adopted and continuing to, for a considerable period thereafter, various states had separate equity courts, and federal courts recognized separate causes of action for equity that were distinguished from suits at common law. See generally, blah, blah, blah. However, commencing in 1845, states began to abandon their separate equity courts. In 1938, federal courts adopted new federal rules of civil procedures for all civil matters, wherein a single form of civil action is provided for all civil suits. See equity jurisprudence. Classification of a cause of action as to whether it seeks a remedy at law or in equity remains important for several reasons of general significance. 1, equitable remedies are generally enforceable by contempt, while legal remedies are not. And 2, generally litigants do not have a right to a jury trial to obtain equitable relief, whereas in many cases a right to a jury trial attaches to the suit at law. And 3, equitable relief is discretionary. Determining whether a particular cause of action seeks remedies at law or in equity is not an easy task. Ooh, I don't know. I don't know any of this at all. Fuck, I feel like I should understand this. Oh, good luck. Hopefully we can ascertain it as we read. Destiny, I understand why a universal injunction may not be allowed, but why wouldn't a district court have the ability to enjoin all those actions within their district? I don't know the answer to that, but I imagine that's going to be what this court case is about. Basically, the issue is that what the Trump government is mad about is the Trump government made the argument, if you listen to the oral arguments, that a district court, a federal court, shouldn't be able to issue an injunction against the government, preventing it from doing some behavior to anybody beyond the actual plaintiffs in a lawsuit. And in my opinion, this sounds very wacky because typically if you're going to enjoin the government from doing something relating to some law it has, it's probably because it's not a good law. But the idea is that the government is arguing is that, so like let's say for instance, let's say that the government was, what the fuck? Let's say that the government was engaging in some behavior where they were dumping raw sewage. The federal government was dumping raw sewage in some guy's backyard, and then somebody sues the government. They're like, we don't like the sewage dump policy that you have. And then the federal court, they win and they issue an injunction against the government. Well, the government's saying, well, hold on. If they don't want us dumping sewage in the backyard, every single person whose backyard we're dumping sewage into, they all have to sue us. One guy can't sue us, and then you provide relief to people who aren't even parties to the lawsuit. That's ridiculous. On my mind, that argument is ridiculous, but that's where we're at, I guess. But we'll read the, we'll see what the, we'll see how they argue it, I guess. Okay. This court has held that the statutory grant encompasses only those sorts of equitable remedies traditionally accorded by courts of equity at our country's inception. Okay. Universal injunctions are not sufficiently analogous to any relief available in the court of equity in England at the time of the founding. Equity offered a mechanism for the Crown to secure justice where it would not be secured by the ordinary and existing processes of law. The origin of English equity, blah, blah, blah. Oh, this is a quote from that. This judicial prerogative of the king thus extended to those causes which the ordinary judges were incapable of determining. Eventually, the Crown instituted the practice of delegating the cases that came before the judicial prerogative to the Chancellor for his sole discretion or decision. The general rule in equity was that all persons materially interested in the suit were to be made parties to it. Injunctions were no exception. There were sometimes suits to restrain the actions of particular officers against particular plaintiffs. Of importance here, suits in equity were brought by and against individual parties, and the Chancellor's remedies were generally party-specific. You cannot have an injunction except against a party to the suit. In sum, under long-standing equity practice in England, there was no remedy remotely like a national injunction. I really need to know what the inequities thing is. It sounds like basically what they're arguing about is that like a court couldn't... So like, for instance, here's the thing that I know is true. Let's say that I sue a company because they made medication that made me sick. If I sue that company, an outcome of that court case can never be that the company has been forced to pay out all the medical bills to every single person who was negatively impacted by that medication. The only way for that to happen is to file a class action lawsuit. The class action lawsuit can denote a classification of people that the court has to approve, and then all of those people are now listed as the plaintiff, meaning they are a party. Parties to a case are either the plaintiff or the defendant. They are now a plaintiff, and now they are entitled to equitable relief. Well, I guess that means equitable relief. Some kind of like payout or something from that court. Are they arguing with examples of how a king behaves? Well, careful. So this is a syllabus. So they're not arguing at all right now. What they're doing is when the... There's three things here. I wish I could remember. When a court is trying to decide how a law should be, when the Supreme Court is, the first thing they look at is it really depends on how they personally feel about it. But the first thing they're supposed to look at is the plain text of a law. So if a law comes out and it says, all men, if they don't have 2-inch dicks, shall be afforded a 10-inch cock sleeve, that's a plain reading English. It doesn't matter how you feel about cock sleeves or dicks. Like, that's it. It's a plain reading of the law. That's all men with 2-inch or less dicks get 10-inch cock sleeves. That's it. But let's say that it says that like all men with 2-inch dicks are now afforded cyborg cocks. Well, let's say that this law was passed in 1740 or whatever, right? Well, cyborg back then might have meant something way different. So now instead of the plain reading of the English, now you might go to like in the history when they passed this, like what was the congressional intention? And then what was the historical analogs to this at the time? How can we ascertain what the meaning was originally when they passed this? What were they trying to do? When the plain reading fails, you might have to go back in time to figure out what's going on. So when they're bringing up like, well, this is what the courts did back in the King of England, a lot of the U.S. legal system is based on the common law system. We were all British, remember, from the not from the United Kingdom, right? It was just from England. And so they're going to be looking at, well, what were laws in England like at the time? Because that's where the early U.S. system was based off of. And that's probably what the people that were framing laws and the Constitution and amendments, that's probably what was in their minds as well. Nor did founding era courts of equity in the United States chart a different course. If anything, the approach traditionally taken by federal courts cuts against the existence of such a sweeping remedy. Consider Scott v. Donald, where the plaintiff successfully challenged the constitutionality of a law on which state officials had relied to confiscate alcohol that the plaintiff kept for personal use. Although the plaintiff sought an injunction barring enforcement of the law against both himself and anyone whose rights were infringed and threatened by it, the court permitted only relief benefiting the named plaintiff. In the ensuing decades, the court consistently rebuffed requests for relief that extended beyond the parties. I'd be interested in reading these underlying cases, but I don't have enough time in the day and all that bullshit. The court's early refusals to grant relief to non-parties are consistent with the party-specific principles that permeate the court's understanding of equity. Oh, another example of neither declaratory nor injunctive relief, the court has said, can directly interfere with enforcement of contested statutes or ordinances except with respect to the particular federal plaintiffs. In fact, universal injunctions were conspicuously non-existent for most of the nation's history. Their absence from 18th and 19th century equity practice settles the question of judicial authority. While equity is flexible, now remember, they're asking this question of judicial authority because it's granted via the Constitution and then the Judiciary Act of, was it 1790? So they're trying to figure out what do they think that meant at the time in the history of the, when this act was passed. What did they mean, right? While equity is flexible, the court's precedent emphasizes that its flexibility is confined within the broad boundaries of traditional equitable relief. Because the universal injunction lacks a historical pedigree, it falls outside the bounds of a federal court's equitable authority under the Judiciary Act. Respondents' counterarguments are unavailing. 1. In an effort to satisfy Grupo Mexicano's historical test, respondents claim that universal injunctions are the modern equivalent of the decree resulting from a bill of peace, a form of group litigation in the Court of Chancery. Respondents contend that the existence of this historic equitable device means that federal courts have the equitable authority to issue universal injunctions under the Judiciary Act. The analogy, however, does not work. True, bills of peace allowed courts of equity to adjudicate the rights of members of dispersed groups without formally joining them to a lawsuit through the usual procedures. Arizona v. Biden. Unlike universal injunctions, however, which reach anyone affected by executive or legislative action, bills of peace involved a group that was small and cohesive. I'm too lazy to read that underlying case. Was this about like healthcare stuff, Arizona v. Biden, or student loan stuff? I wonder how arbitrary this distinction is, but. And unlike universal injunctions, which bind only the parties to the suit, decrees resulting from a bill of peace would bind all members of the group, whether they were present in the action or not. The Bill of Peace lives in modern form, but not as the universal injunction. It is instead analogous to the modern class action, which, in federal court, is governed by Rule 23 of the Federal Rules of Civil Procedure. Rule 23 requires numerosity, such that joinder is impracticable, common questions of law or fact, typicality, and representative parties who adequately protect the interests of the class. The requirement, okay, I'm guessing that Rule 23 of the Federal Rules of Civil Procedure is probably governing how to do a class action lawsuit. Federal Rules of Civil Procedure 23 is for class actions. Okay, and this is telling you how to create a class for a class action, yeah, okay. The requirements for a bill of peace were virtually identical. By forging a shortcut to relief that benefits parties and non-parties alike, universal injunctions impermissibly circumvent Rule 23's procedural protections. 2. Respondents contend that universal injunctions or at least these universal injunctions, are simply an application of the principle that a court of equity may fashion a remedy that awards complete relief. But complete relief is not synonymous with universal relief. It is a narrower concept, long embraced in the equitable tradition, that allows courts to administer complete relief between the parties. To be sure, party-specific injunctions sometimes advantage non-parties, but they do so only incidentally. Here, prohibiting enforcement of the executive order against the child of an individual pregnant plaintiff will give that plaintiff complete relief. Her child will not be denied citizenship, and extending the injunction to cover everyone similarly situated would not render her relief any more complete. Here, prohibiting enforcement of the executive order against the child of an individual pregnant plaintiff will give the plaintiff complete relief. Her child will not be denied citizenship, and extending the injunction to cover everyone similarly situated would not render her any more complete. What does that mean by that? What if they have like other family members that might have birthright citizenship or something? No? That aren't parties to the case? No, I don't know. Again, that's just a syllabus, but... So the individual and associational respondents are wrong to characterize the universal injunction as simply an application of the complete relief principle. The inquiry is more complicated for the state respondents because the relevant injunction does not purport to directly benefit non-parties. Instead, the District Court for the District of Massachusetts decided that a universal injunction was necessary to provide the states themselves complete relief. As the states see it, their harms, financial injuries, and the administrative burdens flowing from citizen-dependent benefits programs cannot be remedied without a blanket ban on the enforcement of the executive order. Children often move across state lines or are born outside their parents' states of residence. Given the cross-border flow, the states say a patchwork injunction would prove unworkable for the provision of certain federally funded benefits. The government retorts that even if the injunction is designed to benefit only the states, it is more burdensome than necessary to redress their asserted harms, and that narrower relief is appropriate. The court declines to take up these arguments in the first instance. The lower courts should determine whether a narrower injunction is appropriate, so we leave it to them to consider these and any related arguments. Okay, so it sounds like one of the arguments from the states is that you can't just you can't selectively enforce this citizenship argument over naturalized citizens, because if a child is born in one state and moves to another state, do we even know who, the patchwork injunction wouldn't work. It would have to be basically all or nothing, I think. At Destiny, why is the Supreme Court so willing to relinquish power from the judiciary to the executive? Do you think it will get to the point where executive orders are akin to construction arguments or to the construction amendments? I don't know. We'll keep reading, but respondents defend. Oh, so that part is remanded to the lower courts, I'm guessing. Respondents defend universal injunctions as a matter of policy. The government advances policy arguments running the other way. As with most questions of law, the policy pros and cons are beside the point. Under the court's well-established precedent, because universal injunctions like a founding era forbear, federal courts lack authority to issue them. Part D. To obtain interim relief, the government must show that it is likely to suffer irreparable harm absent a stay. This means that for the government to do an application to stay to prevent the lower court orders, the government has to show that there's going to be irreparable harm suffered if they don't get a stay basically against what the lower federal courts have ordered. When a federal court enters a universal injunction against the government, it improperly intrudes on a coordinated branch of the government and prevents the government from enforcing its policies against non-parties. Quoting from another case, any time a state is enjoined by a court from effectuating statutes enacted by representatives of its people, it suffers a form of irreparable injury. The court's practice also demonstrates that an applicant need not show it will prevail on the underlying merits when it seeks a stay on a threshold issue. The government here is likely to suffer irreparable harm from the district court's entry of injunctions that likely exceed the authority conferred by the Judiciary Act, and the balance of equities does not counsel against awarding the government interim relief. A partial stay will cause no harm to respondents because they will remain protected by the preliminary injunctions to the extent necessary and appropriate to afford them complete relief. When a court concludes that the executive branch has acted unlawfully, At Destiny, suffered by the government or all parties to the case. Wait, suffered by the government or all parties to the case in regards to what? Here the court is arguing it's looking at a balance of equities. When you're providing this type of like pre-trial relief, like before a trial, before the actual like court case is like taken place and been ruled on, it's a bunch of balancing games. So one of the questions the court will ask here is, okay, well, the lower courts issued a stay saying the government couldn't enforce its order, and now we're looking at that stay. Well, if the lower courts issue the stay, and the government is likely to suffer irreparable injury because it can't enforce its policy, so that's one way. One balance to weigh against. But let's say that their injunction, sorry. Let's say that the Supreme Court issues a stay against those injunctions, then the government won't be harmed. Well, will the parties to the case be harmed? No, the parties to the case won't be harmed because the preliminary injunction still narrowly covers the parties to the case. So the only people that could be harmed here are non-parties to the case that would be impacted by this law. So the balance of equities here, they would argue, is in favor of granting the government a stay against the lower court's injunction, basically. Where were we? When a court concludes that the executive branch has acted unlawfully, the answer is not for the court to exceed its power to. The government's applications for partial stays of the preliminary injunctions are granted, but only to the extent that the injunctions are broader than necessary to provide complete relief to each plaintiff withstanding to sue. Applications for partial stays granted. Amy Comey Barrett, Comey, not Coney, right? It's Comey. I always fuck her name out, the middle name. It's Coney. Amy Coney Barrett delivered the opinion of the court, so she's going to be writing the opinion, in which Roberts, Thomas, Alito, Gorsuch, and Kavanaugh all join. Thomas will file a concurring opinion that will probably be schizophrenic, although Gorsuch joins that, so maybe it won't be as schizophrenic. Alito is kind of schizo, and Thomas joined that one. That one may be super schizo. Kavanaugh writes his own opinion. Jesus, oof, we're all writing on this. And then Sotomayor, our liberal in the court, is joined by the other two liberals, filed a dissenting opinion which Kagan and Jackson join, and then Jackson writes her own opinion. Whew! Everybody's writing on this shit. Okay. Okay. Here are the three underlying cases that all issued an injunction, preliminary injunction. So before the court case, these all issued preliminary injunctions against the government on their executive order about birthright citizenship. These were in three separate circuits, so three entirely separate circuit courts. And then Trump and the government all filed for a stay, and the Supreme Court is now ruling on that stay and has granted the application for partial stay, meaning that the Supreme Court has said the preliminary injunctions only apply to the parties in the case. They cannot be broader than the parties in the case right now, which is where we're at. Okay. Okay. Jen says, I don't think we should read it. I think we should watch lawyers explain the effects. I read like 6 pages or so. I love you, but at this point in my life, I don't trust anybody's summary on anything. And I feel like when the Supreme Court is writing, I feel like the writing is generally pretty accessible. So I feel like it's worth reading. We have the time for it. And I feel like this is like kind of important stuff. So I'd rather just read it. I don't think any of this is beyond our ability to grasp, as I don't even know what equitable relief is in the opening. Yeah. Okay. Justice Barrett delivered the opinion of the court. The United States has filed 3 emergency applications. Why is President Trump like a named party on this case? I'm curious. Maybe because he wrote the executive order? Maybe? I don't know. The United States has filed 3 emergency applications challenging the scope of a federal court's authority to enjoin government officials from enforcing an executive order. Traditionally, courts issued injunctions prohibiting executive officials from enforcing a challenged law or policy only against the plaintiffs in the lawsuit. The injunctions before us today reflect a more recent development: district courts asserting the power to prohibit enforcement of a law or policy against anyone. These injunctions, known as universal injunctions, likely exceed the equitable authority that Congress has granted to federal courts. We therefore grant the government's applications to partially stay the injunctions entered below. Our footnote here is, such injunctions are sometimes called nationwide injunctions, reflecting their use by a single district court to bar the enforcement of a law anywhere in the nation. But the term universal better captures how these injunctions work. Even a traditional parties-only injunction can apply beyond the jurisdiction of the issuing court. And then quoting from Steele v. Bulova Watch Company, when exercising its equity powers, a district court may command persons properly before it to cease or perform acts outside its territorial jurisdiction. The difference between a traditional injunction and a universal injunction is not so much where it applies, but whom it protects. A universal injunction prohibits the government from enforcing the law against anyone, anywhere. The government doesn't... Oh, okay, that was the first footnote. Okay. We therefore grant... Okay. The applications before us concern 3 overlapping universal preliminary injunctions entered by 3 different district courts. The plaintiffs, individuals, organizations, and states sought to enjoin the implementation and enforcement of President Trump's executive order number 14160. The footnote here is, the government does not dispute, nor could it, that the individual plaintiffs have standing to sue, but it argues that the states lack third-party standing because their claims rest exclusively on the rights of individuals. It also challenges the district court's authority to grant relief to the organization's members who are not identified in the complaints. We do not address these arguments. Okay. See, protecting the meaning and value of American citizenship. Okay. The executive order identifies circumstances in which a person born in the United States is not subject to the jurisdiction thereof and is thus not recognized as an American citizen. Specifically, it sets forth the policy of the United States to no longer issue or accept documentation of citizenship in 2 scenarios. 1, when a person's mother was unlawfully present in the United States and the person's father was not a U.S. citizen or lawful permanent resident at the time of said person's birth. Or 2, when a person's mother's presence in the United States was lawful but temporary, and the person's father was not a United States citizen or lawful permanent resident at the time of said person's birth. The executive order also provides for a 30-day ramp-up period. During that time, the order directs executive agencies to develop and issue public guidance regarding the order's implementation. Guidance. I don't know what the fuck that was about. Okay. Oh, hour and 20 minutes fine. Good job. The plaintiffs filed suit alleging that the executive order violates the 14th Amendment's Citizenship Clause, Section 1, as well as Section 1 as well as Section 201 of the Nationality Act of 1940. In each case, the district court concluded that the executive order is likely unlawful and entered a universal preliminary injunction barring various executive officials from applying the policy to anyone in the country. And in each case, the Court of Appeals denied the government's request to stay the sweeping relief. The government has now filed 3 nearly identical applications seeking to partially stay the universal preliminary injunctions and limit them to the parties. And then it's the 3 applications for partial state injunction. The applications do not raise, and thus we do not address, the question of whether the executive order violates the Citizenship Clause or Nationality Act. The issue before us is one of remedy, whether under the Judiciary Act of 1789, federal courts have equitable authority to issue universal injunctions. Because the applications are materially identical, we cite only the application in number 24A884 throughout the rest of the opinion. Okay. Does a protective destiny as a lawful permanent resident of Chat's mother? Yes. Because I'm a citizen. The question whether Congress has granted federal courts the authority to universally enjoin the enforcement of an executive or legislative policy plainly warrants our review, as members of this court have repeatedly emphasized. This is citing Gorsuch in an earlier case. I would take this case now to resolve definitively the question of whether a district court may issue universal injunctive relief. Gorsuch, another quote from Gorsuch. The propriety of universal injunctive relief is a question of great significance that has been in need of the court's attention for some time. And then this is from Kavanaugh. Universal injunctions present an important question that could warrant our review in the future. This is just quoting all the other. And then Thomas saying, if universal injunctions popularity continues, this court must address their legality. On multiple occasions and across administrations, the Solicitor General has asked us to consider the propriety of this expansive remedy. And here's another. Okay, I'm so curious. Where my legal people? How was the court case done when Biden was trying to do the student loan relief? Was that via basically a universal injunction against the government for forgiving from forgiving the student loan debt, or what was the structure of that? I feel like I would have to go read that case. How do they work out the whole stateless thing? I would have to go and look at what the government is specifically saying, but I'm not sure if stateless people necessarily would pop up for what they're looking for here. Maybe they would, but I'm not sure. Wait, did I miss a question? Hold on. Oh, no, okay. On multiple occasions and across administrations, the Solicitor General has asked us to consider the propriety of this expansive remedy. Okay. It is easy to see why. By the end of the Biden administration, we had reached a state of affairs where almost every major presidential act was immediately frozen by a federal district court. The trend has continued. During the first 100 days of the second Trump administration, district courts issued approximately 25 universal injunctions. As the number of universal injunctions has increased, so too has the importance of the issue. How do you stop I'm trying to think of how you stop a government from doing a bad thing. Do you just have to rule the law unconstitutional? I'm not sure. I don't know. I'm sure it'll be addressed in here, but. The government is likely to succeed on the merits of its argument regarding the scope of relief. See Nkin v. Holder, holding that for a stay application to be granted, the applicant must make a strong showing that it is likely to succeed on the merits. A universal injunction can be justified only as an exercise of equitable authority, yet Congress has granted federal courts no such power. Our decision rests solely on the statutory authority that federal courts possess under the Judiciary Act of 1789. We express no view on the government's argument that Article 3 forecloses universal relief. The Judiciary Act of 1789 endowed federal courts with jurisdiction over all suits in equity. Section 11, 1 statute, 70, and still today, this statute is what authorizes the federal courts to issue equitable remedies. Though flexible, this equitable authority is not freewheeling. We have held that the statutory grant encompasses only those sorts of equitable remedies traditionally accorded by courts of equity at our country's inception. Can we get a fucking color? Okay. Weird and possibly dumb question. If states were to put in their constitution that they allow birthright citizenship as a right, would it then be a state versus government issue? So I believe that questions of citizenship are delegated to the United States government. I don't believe that states are allowed to make determinations of or make statements towards whether or not an individual is granted citizenship to the United States of America, because citizenship is a federal government question. You don't have citizenship to like a state or anything like that. Also quoting Payne v. Hook, the equity jurisdiction conferred on the federal courts is the same that the High Court of Chancery in England possesses. Footnote 5, see also Guaranteed Trust, Co. v. York. The federal courts have no power that they would not have had in any event when courts were given cognizance by the First Judiciary Act of suits in equity. The settled doctrine of this court is that the remedies in equity are to be administered not according to the state practice, but according to the practice of courts of equity in the parent country. Okay, Jesus. We must therefore ask whether universal injunctions are sufficiently analogous to the relief issued by the High Court of Chancery in England at the time of the adoption of the Constitution and the enactment of the original Judiciary Act. The answer is no. Neither the universal injunction nor any analogous form of relief was available in the High Court of Chancery in England at the time of the founding. Equity offered a mechanism for the Crown to secure justice where it would not be secured by the ordinary and existing processes of law. This judicial prerogative of the king thus extended to those causes which the ordinary judges were incapable of determining. Eventually, the Crown instituted the practice of delegating the cases that came before the judicial prerogative to the Chancellor for his sole decision. This became the common mode of dealing with such controversies. Then why do they allow states to determine citizenship status for voting? Why do they allow states to determine citizenship status for voting? Because the time and manner, I should have these memorized for what part in the Constitution is, but the time and manner of how you do your elections, or the place and manner, I think, sorry. The time, I think, can be delegated, or is dictated by the federal government, but the place and manner, I think, is left to the states explicitly in the Constitution. That could be interesting, though, because states are the ones that provide the proof of citizenship, your birth certificate. Yeah, but I don't know if a birth certificate matters as much as like a social security number. I don't know the interplay between how that works, though. This judicial prerogative of the king, okay. Of importance here, suits in equity were brought by and against individual parties. Okay. Is a suit in equity, when you talk about this, you're talking about stuff that isn't criminal in nature. Suits in equity are basically just things where you're looking for equitable relief, which is not criminal punishment, basically, right? So that's what suits in equity means, right? It's like basically all like civil cases or cases where you're looking for some kind of payout or relief to be provided, I think, for some injury, I think. Okay. Could a state just refuse to enforce immigration law? Kind of. States don't have to enforce immigration law. Immigration law is enforced by the federal government. So the Department of Homeland Security, ICE, stuff like that. States can cooperate with the federal government if they wish. They can turn people over in their states to the federal government for deportation, for instance, if they want. Or states could not cooperate, or cities could not cooperate. Those people are called sanctuary states or sanctuary cities. That's what a sanctuary city is. Oh, wait. Equity is anything that's not monetary damages, like injunctions. Oh, okay. But it's not criminal, I guess, right? Okay. Wow, Beanpod, thanks for the gifts, buddy. Of importance here, suits in equity were brought by and against individual parties. Indeed, the general rule in equity was that all persons materially interested in the suit were to be made parties to it. Injunctions were no exception. There were sometimes suits to restrain the actions of particular officers against particular plaintiffs. Quoting from another case, and in certain cases, the attorney general could be a defendant. The chancellor's remedies were also typically party specific. As a general rule, an injunction could not bind one who was not a party to the case, to the cause. I'm quoting from Iveson v. Harris. You cannot have an injunction except against a party to the suit. Suffice it to say, then, under longstanding equity practices in England, there was no remedy remotely like a national injunction, nor did founding-era courts of equity in the United States chart a different course. If anything, the approach traditionally taken by federal courts cuts against the existence of such a sweeping remedy. Consider Scott v. Donald, where the plaintiff successfully challenged the constitutionality of a law on which state officials had relied to confiscate alcohol that the plaintiff kept for personal use. Although the plaintiff sought an injunction barring enforcement of the law against both himself and anyone else whose rights were infringed and threatened by it, this court permitted only a narrower decree between the parties named as plaintiff and defendants in the bill. Footnote number 6, though the principal dissent claims otherwise, we do not treat Scott as dispositive. The lack of historical analog is dispositive. Scott simply illustrates that as late as 1897, the court adhered to a party-specific view of relief, and while the principal dissent relies on Smith v. Ames in 1898, which was next year, as a counterexample, Scott, see post. It is unclear why. Even supporters of the universal injunction recognize that the decree that Smith affirmed did not reach beyond the parties, quoting circuit court order that enjoined state officials from enforcing the statute against said railroad companies. Okay. She's fighting with the dissent in her footnote here. Okay. In the ensuing decades, we consistently rebuffed requests for relief that extended beyond the parties. Quoting from Perkins v. Lucan Steele, the benefits of the court's injunction improperly extended to bidders throughout the nation who were not parties to any proceeding, who were not before the court, and who had sought no relief. Frothingham v. Mellon decided with Massachusetts v. Mellon, concluding that the court lacked authority to issue preventative relief. That would apply to people who suffer in some indefinite way in common with people generally. Bertle explaining that the Frotham analysis intertwines concepts of equity, remedies, and judicial power. As Justice Nelson put it, while writing Circuit, there is scarcely a suit at law or in equity in which a general statute is interpreted that does not involve a question in which other parties are interested. But to allow all persons subject to the statute to be treated as parties to a lawsuit would confound the established order of judicial proceedings. Our early refusals to grant relief to non-parties are consistent with the party-specific principles that permeate our understanding of equity. Neither declaratory nor injunctive relief, we have said, can directly interfere with enforcement of contested statutes or ordinances except with respect to particular federal plaintiffs. It is an elementary principle, quoting from, I'm guessing Gregory v. Stetson, it is an elementary principle that a court cannot adjudicate directly upon a person's right without having him either actually or constructively before it. This principle is fundamental. And then quoting from something from Bod, is this from a journal? Noting the party-specific understandings of what equitable remedies do. Is that a law professor? I think we read, that was the guy who wrote the paper on the whatever bullshit that we read before. Okay. Wait, okay. I don't think I've been more mad with SCOTUS since Roe was overturned. I mean, we'll see. I mean, the court could be right here. I will read the dissent, I guess, to see how they argue. But I guess I would just have procedural questions for how, when the government is doing, like, bad stuff that gets overturned by a federal court, how are those issues ordinarily addressed? Because I don't think every single person in the United States sues the government. I don't know. I guess I'm just not sure what that process even looks like, but we'll see what the dissent says, I guess. And there's like everybody decided to write their own blog post on this as well, so we'll see what all the other Supreme Court justices wrote on this too. In fact, universal injunctions were not a feature of federal court litigation until sometime in the 20th century. See Bray, multiple chancellors discussing various rationales for the birth of the universal injunction. See also application in number 24 law, which is this. The D.C. Circuit issued what some regard as the first universal injunction in 1963. See Wirtz v. Balder Electric Company, enjoining the Secretary of Labor with respect to the entire electric motors and generators industry, not just the named plaintiffs to the lawsuit. Yet, such injunctions remained rare until the turn of the 21st century, when their use gradually accelerated. See Bray, multiple chancellors, and Harlem, Valley Transport. One study identified approximately 127 universal injunctions issued between 1963 and 2023. That's probably worth noting this, if this is true. Even if they can make a coherent argument, it spits in the face of what they did under Biden. At this point, it's bluntly political. Yeah, I'm very curious about the. I'm very curious about the underlying. Or I'm sorry, I don't know how that case went. I wasn't reading Supreme Court cases back then. I'm curious. Maybe I'll go through it afterwards. How many pages is that Supreme Court ruling? "96 of them, over three-quarters, were issued during the administrations of President George W. Bush, President Obama, President Trump, and President Biden." Do Supreme Court justices ever have communication with the sitting president, or is that considered improper? I'm trying to figure out why everything seems so blatantly partisan. I mean, that's probably not okay. But careful, you should know the rationale before you just call it partisan, okay? I don't know if maybe this argument will end up being good. Maybe not. We'll see. I'm curious how this, does this apply retroactively to other federal injunctions, or I don't know. We'll see. The bottom line, the universal injunction was conspicuously non-existent for most of our nation's history. Its absence from 18th and 19th century equity practice settles the question of judicial authority. Footnote 8, the principal dissent faults us for failing to identify a single founding era case in which this court held that universal injunctions exceed a federal court's equitable authority. But this absence only bolsters our case that this court had no occasion to reject the universal injunction as inconsistent with traditional equity practice, merely demonstrates that no party even bothered to ask for such a sweeping remedy because no court would have entertained the request. Equitable powers conferred by the judiciary do not include the power to... Okay. That the absence continued into the 20th century renders any claim of historical pedigree still more implausible, even during the deluge of constitutional litigation that occurred in the wake of ex parte Young throughout the Lochner era and at the dawn of the New Deal. Universal injunctions were nowhere to be found. Had federal courts believed themselves to possess the tool, surely they would not have let it lay idle. Faced with this timeline, the principal dissent accuses us of misunderstanding the nature of equity as being frozen in amber at the time of the Judiciary Act. Quoting from Sotomayor's dissent in this case. Not so. We said it before, and say it again. Equity is flexible. At the same time, its flexibility is confined within the broad boundaries of traditional equitable relief. A modern device need not have an exact historical match, but under Grupo Mexicano, it must have a founding era antecedent, and neither the universal injunction nor a sufficiently comparable predecessor was available from a court of equity at the time of our country's inception. Because the universal injunction lacks a historical pedigree, it falls outside the bounds of a federal court's equitable authority under the Judiciary Act. Footnote 9 is, notwithstanding Grupo Mexicano, the principal dissent invokes, ex parte Young, as support for the proposition that equity can encompass remedies that have no analog in the relief exercised in the English Court of Chancery, because ex parte Young permits plaintiffs to obtain plaintiff protection injunctions against government officials, and the English Court of Chancery could not enjoin the Crown or English officers. But contrary to the principal dissent's suggestion, ex parte Young does not say, either explicitly or implicitly, that courts may devise novel remedies that have no background in traditional equitable practice. Historically, a court of equity could issue an anti-suit injunction to prevent an officer from engaging in torturous conduct. Ex parte Young justifies its holding by reference to a long line of cases authorizing suits against state officials in certain circumstances. Support for the principal dissent's approach is found not in ex parte Young, but in Justice Ginsburg's partial dissent in Grupo Mexicano, which eschews, right? Eschews. It's CH, right? The governing historical approach in favor of a dynamic equity jurisprudence. Okay, wait. It's eschews? Eschews. Okay. Okay. And then footnote 10 was, nothing we say today resolves the distinct question of whether the Administrative Procedures Act authorizes federal courts to vacate federal agency action, authorizing courts to hold unlawful and set aside agency action. Okay. Respondents raised several counter-arguments, which the principal dissent echoes. First, they insist that the universal injunction has a sufficient historical analog, a decree resulting from a bill of peace. Second, they maintain that universal injunctions are consistent with the principles that a court of equity may fashion complete relief for the parties. Third, they argue that universal injunctions serve important policy objectives. 1. In an effort to satisfy Grupo Mexicano's historical test, respondents claim that universal injunctive relief does have a founding era forebear, the decree obtained on a bill of peace, which was a form of group litigation permitted in English courts. This bill allowed the chancellor to consolidate multiple suits that involved a common claim the plaintiff could have against multiple defendants, or some kind of common claim that multiple plaintiffs could have against a single defendant. Universal injunctions are analogous to this traditional equitable device, respondents say, so federal courts have authority under the Judiciary Act to issue them. The analogy does not work. True, bills of peace allowed courts of equity to adjudicate the rights of members of dispersed groups without formally joining them to a lawsuit through the usual procedures. This is where they're going to make the class action argument, huh? Even so, their use was confined to limited circumstances. Unlike universal injunctions, which reach anyone affected by legislative or executive action, no matter how large the group or how tangential the effect, a bill of peace involved a group that was small and cohesive, and the suit did not resolve a question of legal interpretation for the entire realm. And unlike universal injunctions, that's probably good. That's our argument here. And unlike universal injunctions, which bind only the parties to the suit, decrees obtained on a bill of peace would bind all members of the group, whether they were present in the action or not. Quoting from Smith v. Swarmstedt, when a court of equity permits a portion of the parties in interest to represent the entire body, the decree binds all of them the same as if they were all before the court. See also Story, section 120. In most, if not in all cases of this sort, the decree obtained upon such a bill will ordinarily be held binding upon all other persons standing in the same predicament. As Chief Judge Sutton aptly put it, Sutton, right? The domesticated animal, known as a bill of peace, looks nothing like the dragon of nationwide injunctions. The bill of peace lives in modern form, but not as the universal injunction. It evolved into the modern class action, which is governed in federal court by Rule 23, the Federal Rules of Civil Procedure. The class action suit was an invention of equity, and while Rule 23 is in some ways more restrictive of representative suits than the original bills of peace, it would still be recognizable to an English chancellor. Rule 23 requires a numerosity such that joinder is impracticable, common questions of law or fact, typicality, and representative parties who adequately protect the interests of the class. The requirements for a bill of peace were virtually identical. None of these requirements is a prerequisite for a universal injunction. Okay. Rule 23's limits on class actions underscore a significant problem with universal injunctions. A properly conducted class action, we have said, can come about in federal courts in just one way, through the procedure set out in Rule 23. Quoting from Smith v. Bayer Corporation, one or more members of a class may sue or be sued as representative parties on behalf of all members only if Rule 23A's requirements are satisfied, emphasis added. Yet, by forging a shortcut to relief that benefits parties and non-parties alike, universal injunctions circumvent Rule 23's procedural protections and allow courts to create de facto class actions at will. Okay, just as a heads up, if you are here, this is going to be a very, very, very boring ruling. This is going to be 100% procedural. None of the questions about citizenship are going to be answered or anything, and this is going to be like a purely procedural thing. Not that that makes it unimportant, but... Why bother with a Rule 23 class action when the quick fix of a universal injunction is on the table? Why go through the trouble of complying with local attachment and garnishment statutes when this all-purpose pre-judgment injunction is available? The principal dissent's suggestion that these suits could have satisfied Rule 23's requirements simply proves that universal injunctions are a class action workaround. The taxpayer suit is a similarly inadequate historical analogy. If a successful taxpayer suit, or in a successful taxpayer suit, a court would enjoin the collection of an unlawful tax against taxpayers joined as co-plaintiffs or by one taxpaying suing on behalf of himself and all others similarly situated. To be sure, some state courts would occasionally enjoin the enforcement and collection of taxes against an entire community, even when a single taxpayer sued on his own account, but the practice of extending relief with respect to any taxpayer was not adopted by state courts until the mid-19th century, and even then, not all states were willing to provide such sweeping relief. This post-founding practice of some state courts thus sheds minimal light on federal courts' equitable authority under the Judiciary Act. What is more, in Frothingham, we refuse to allow a single taxpayer to challenge a federal appropriations act. That counsels against placing much, if any, reliance on taxpayer suits as justification for the modern universal injunction. At Destiny, were there oral arguments for this decision? Would be interested in hearing the arguments that came before the decision. Yeah, there were. We listened to them on stream, but it's like 2 hours, so... yeah. Did we get a footnote here? No, not yet. Respondents contend that universal injunctions, or at least these universal injunctions, are consistent with the principle that a court of equity may fashion a remedy that awards complete relief. We agree that the complete relief principle has deep roots in equity, but to the extent respondents argue that it justifies the award of relief to non-parties, they are mistaken. Footnote here, Justice Jackson, for her part, thinks the premise that universal injunctions provide relief to non-parties is suspect because, in her view, non-parties may benefit from an injunction, but only the plaintiff gets relief. The availability of contempt proceedings suggests otherwise. Consider the civil contempt context. Under traditional principles of equity practice, courts may impose civil contempt sanctions to coerce a defendant into compliance with an injunction. Generally, civil contempt proceedings occur between the original parties to the lawsuit. Okay, that's an interesting argument. So, this is so procedural. So Justice Jackson sounds like she's going to argue in her dissent that a universal injunction isn't giving relief to non-parties which is what their big contention is, it actually is it's just benefiting them. It's not giving relief to them. It's just benefiting them. So we're not actually violating anything of the Judiciary Act. But then it sounds like Amy's counter argument is, well, you're saying that it's just a benefit, but not a relief. However, courts can enforce relief that's been granted by them with civil contempt charges. And here, if the benefit isn't provided to non-parties of the case via a universal injunction, then a civil contempt proceeding could occur as a result. So it's not really a benefit. In a way, non-parties to the case are being granted relief, which is one of the arguments that they would be using against this being allowed, I guess. Destiny, the fact that the immunity ruling exists and knowing the criticality is selective is infuriating, no? I mean, that's a totally different thing than this, but like I said, maybe if I read through that Biden case, I'm curious. So apparently the Biden Solicitor General made all these universal injunction arguments in their application of Biden v. Nebraska, but I don't see the court addressing their opinion at all. It might have been procedural since they sought cert before judgment. I don't know how those types of appeals work. Oh yeah, I'd have to go read it, but... Complete relief is not synonymous with universal relief. It is a narrower concept. The equitable tradition has long embraced the rule that courts generally may administer complete relief between the parties. While party-specific injunctions sometimes advantage non-parties, they do so only incidentally. Consider an archetypal case. A nuisance in which one neighbor sues another for blasting loud music at all hours of the night. To afford the plaintiff complete relief, the court has only one feasible option: order the defendant to turn her music down, or better yet, off. That order will necessarily benefit the defendant's surrounding neighbors too. There is no way to peel off just the portion of the nuisance that harmed the plaintiff, quoting from Rogers. But while the court's injunction might have the practical effect of benefiting non-parties, that benefit is merely incidental. Footnote 12. But wait, we missed one footnote. Oh, it was continuing from the last one. Page of enforcing. Sorry, oh shit, I missed this last footnote up here. But a federal court's power in civil contempt proceedings is determined by the requirements of full remedial relief to effect compliance with its decrees. And when an order grants relief to a non-party, as is the case with universal injunctions, the procedure for enforcing the order is the same as for... Oh, this is basically stating what I said before. So a non-party covered by a universal injunction is likely to reap both the practical benefit and the formal relief of the injunction. Okay. And then footnote 12 is, there may be other injuries for which it is all but impossible for courts to craft relief that is complete and benefits only the named plaintiffs. Okay. But while the court's injunctions may have the practical effect of benefiting non-parties, the benefit is merely incidental. Okay. Okay. As a matter of law, the injunction's protection extends only to the suing party, to the suing plaintiff, as evidenced by the fact that only the plaintiff can enforce the judgment against the defendant responsible for the nuisance. If the nuisance persists and another neighbor wants to shut it down, she must file her own suit. Footnote 13, the new plaintiff might be able to assert non-mutual offensive issue preclusion. See, I don't know what the fuck that means, setting forth prerequisites for applying the doctrine, but non-mutual offensive issue preclusion is unavailable against the United States. See U.S. v. Mendoza. That universal injunctions end run this rule is one of the government's objections to them. Non-mutual offensive issue preclusion. Non-mutual offensive issue preclusion occurs when a party who is not involved in a previous lawsuit uses the result of that suit to prevent a party from re-litigating an issue in a subsequent case. This is allowed in some jurisdictions, but only under specific circumstances to afford unfairness to the party against whom it is being asserted. Okay. Offensive collateral estoppel is a type of collateral estoppel, also termed issue preclusion. The doctrine barring a party from relitigating an issue decided against that party in an earlier action, even if the second action is significantly different from the first. Offensive collateral estoppel is asserted by a plaintiff in a suit to prevent the defendant from relitigating an issue previously decided against the defendant. The opposite is defensive collateral estoppel, which, okay, makes sense. Doesn't this ruling mean that Trump can write an EO saying suing the government is illegal, and since an injunction can't be put in place while the lawsuit is happening, the EO would stand? This is about issuing, actually, my understanding is this ruling goes further than just preliminary injunctions. This is a ruling that seems to be shooting down all universal injunctions. But I don't know how you stop like a law that you would deem unconstitutional. I don't know, maybe, or a law that's not okay. I don't know if that just means that I don't know what that means. What kind of relief? What does it mean if you're seeking relief from the Supreme Court to declare a law unconstitutional? I don't know what that means. If that's like an equitable relief or what that, yeah, I'm not sure. Yeah, I don't know. We'll see. I'm sure the other people will be bringing it up, the dissent. The individual and associational respondents are therefore wrong to characterize the universal injunction as simply an application of the complete relief principle. Under this principle, the question is not whether an injunction offers complete relief to everyone potentially affected by an allegedly unlawful act. It is whether an injunction will offer complete relief to the plaintiffs before the court. Injunctive relief should be no more burdensome to the defendants than necessary to provide complete relief to the plaintiffs. Here, prohibiting enforcement of the executive order against the child of an individual pregnant plaintiff will give that plaintiff complete relief. Her child will not be denied citizenship. Extending the injunction to cover all other similarly situated individuals would not render her relief any more complete. The complete relief inquiry is more complicated for the state respondents because the relevant injunction does not purport to directly benefit non-parties. Instead, the district court for the District of Massachusetts decided that a universal injunction was necessary to provide the states themselves with complete relief. The states maintain that the district court made the right call. As the states see it, their harms, financial injuries, and the administrative burdens flowing from citizen-dependent benefit programs cannot be remedied without a blanket ban on the enforcement of the executive order. Children often move across state lines or are born outside their parents' state of residence. Given the cross-border flow, the states say, a patchwork injunction would prove unworkable because it would require them to track and verify the immigration status of the parents of every child, along with the birth state of every child for whom they provide certain federally funded benefits. The government, unsurprisingly, sees matters differently. It retorts that even if the injunction is designed to benefit only the states, it is more burdensome than necessary to redress their asserted harms. After all, to say that a court can award complete relief is not to say that it should do so. Complete relief is not a guarantee. It is the maximum a court can provide. And in equity, the broader and deeper the remedy the plaintiff wants, the stronger the plaintiff's story needs to be. In short, the essence of equity jurisdiction has been the power of the chancellor to do equity and to mold each decree to the necessities of the particular case. And then footnote 14. The District Court for the Western District of Washington acknowledged the state respondent's complete relief argument, but primarily granted a universal injunction on the basis that the extreme nature of the equities alone warranted nationwide relief. Destiny. Federal district courts can find a law unconstitutional, but it is only so in that district unless it gets to the Supreme Court and they agree. Is that true? Destiny. Isn't the argument, had the federal courts thought they had this power, they surely wouldn't have let it lay idle? Super ironic considering the same court invented immunity for Trump. Can't you say that the presidents behaved under the assumption that they were criminally liable for their decisions? Absolutely. That's a good hypocrisy. That's absolutely true. But okay. So the TLDR of this decision is that the lower courts can provide relief to their jurisdiction through the injunction, but only the SCOTUS. No. This has to do with the fact that you can provide relief only to parties of the case. Okay. Leaning on these principles, the government contends that narrower relief is appropriate. For instance, the district court could forbid the government to apply the executive order within the respondent states, including to children born elsewhere but living in those states. Application, or the government says outside of that, or the government says the district court could direct the government to treat covered children as eligible for purposes of federally funded welfare benefits. It asks us to stay the injunction insofar as it sweeps too broadly. We decline to take up these arguments in the first instance. The lower courts should determine whether a narrower injunction is appropriate. We therefore leave it to them to consider these and any related arguments. Does this mean that Trump can effectively legislate as a king now with EOs because they're unable to be challenged by lower courts? Again, I just don't have a good... I don't know if these all get challenged through the Administrative Procedures Act, or I don't know how that works or what that looks like. I just don't have an answer to that right now. But I don't know. Like I said, maybe that'll come up here. Or I'll just need to read through some procedure for how that works, I guess. Respondents also defend universal injunctions as a matter of policy. They argue that a universal injunction is sometimes the only practical way to quickly protect groups from unlawful government actions. They quote this case, see also Frost and Defense of National, suggesting that universal injunctions are appropriate when not all interested parties can come quickly to court. Sotomayor is going to quote this apparently in her dissent. Respondents also contend that universal injunctions are an appropriate remedy to preserve equal treatment among individuals when the executive branch adopts a facially unlawful policy. And they suggest that forcing plaintiffs to proceed on an individual basis can result in confusion or piecemeal litigation that imposes unnecessary costs on courts and others. So, they insist, universal injunctions must be permitted for the good of the system. The government advances policy arguments running the other way. Echoing Chief Judge Sutton, the government asserts that avoiding a patchwork enforcement system is a justification that lacks a limiting principle and would make nationwide injunctions the rule rather than the exception for challenges to many kinds of federal law. Keep in mind that patchwork argument, though, was a really good argument to get rid of the Trump ballot ban. They didn't like the patchwork that might be created as a result of Section 3 of the 14th Amendment, so they took away the ability of states to enforce that, but okay. It stresses, as the principal dissent also observes, that universal injunctions incentivize forum shopping since a successful challenge in one jurisdiction entails relief nationwide. In a similar vein, the government observes that universal injunctions operate asymmetrically. A plaintiff must win just one suit to secure sweeping relief. But to fend off such an injunction, the government must win everywhere. Footnote 15, the government contrasts this with class actions. A judgment in a Rule 23 class action case, favorable or not, binds the whole class. So if the defendant wins, it is protected from future suits. But because an adverse ruling on a request for universal relief lacks this preclusive effect, plaintiffs can continue to file in different forums until they find a court willing to award such relief. Okay, wait, we just learned about a thing. Why wouldn't that other thing apply here? It was called defensive collateral estoppel. Like if a defendant has already litigated an issue, couldn't they just assert this defensive collateral estoppel and say, I've already litigated this shit with somebody else, fuck them? Someone in YouTube said the government should have to win everywhere. Well, no, I mean, like, this argument is legitimate. What they're basically saying is, like, let's say the government passes a new law saying everybody has to jog, 1 mile a day because we all decided that that's what let's say somebody sues the government and says this is discriminatory against fat people. And then let's say that they lose. And then let's say somebody else sues and they lose. And let's say somebody else sues. And let's say like 100 people sue, they all lose. 1,000 people sue, they all lose. 1 million people. Finally, somebody in the state of California sues. We have our wonderful activist court, our oh my god, why am I mixing up 11th Circuit and 9th Circuit? The 9th Circuit is the the quote-unquote activist one, right? There's a Ninth Circuit, California, and Washington, and Oregon. Finally, a judge hears it, and they're like, you know what? You're right. This is unfair. We're going to issue a nationwide injunction against the enforcement of this jogging law. Well, the government has successfully defended itself in 10,000 cases, but then in the 10,001th case, somebody won in some circuit, and now there's an injunction. Oh, estoppel doesn't apply to government according to this other case. Oh, you're right. They just got it right. Okay. That's the government's argument here, which I think is kind of like I think that's a fair argument, right? But I think the estoppel relates to ultimate decisions, though, not to injunctions. I think that an injunction can be an ultimate decision. Preliminary injunctions are preliminary, obviously, not an ultimate. But I think an injunction can be a relief granted at the end of a court case. You can remember it as a 9 on the clock. It's on the left, therefore West Coast. Wow, thanks, buddy. Moreover, the government contends the practice of universal injunctions means that highly consequential cases are often decided in a fast and furious process of rushed, high stakes, and low information decision making. When a district court issues a universal injunction, thereby halting the enforcement of federal policy, the government says that it has little recourse but to proceed to the Court of Appeals for an emergency stay. The loser in the Court of Appeals will then seek a stay from this court. This process forces courts to resolve significant and difficult questions of law on a highly expedited basis and without full briefing. The upshot, as with most disputed issues, there are arguments on both sides, but as with most questions of law, the policy pros and cons are beside the point. Under our well-established precedent, the equitable relief available in the federal courts is that traditionally accorded by courts of equity at the time of our founding. Is that traditionally accorded by courts of equity at the time of our founding? Nothing like a universal injunction was available at the founding, or for that matter, for more than a century thereafter. Thus, under the Judiciary Act, federal courts lack authority to issue them. Why would you? I don't think she should have written about this at all. I don't know why she would have provided any of the arguments here at all if she was just going to say, we're not going to address that, it doesn't matter. I feel like it was inappropriate for her to write on this at all. She should just say, we're not addressing that because it doesn't matter if it's good or bad policy. It wasn't available under the Judiciary Act, but okay. Do we have a footnote 16? Acknowledging these problems, the principal dissent admits that there may be good reasons not to issue universal injunctions in the typical case. This concession, while welcome, is inconsistent with the position that the universal injunction is a nothing-to-see-here extension of the kind of decree obtained on a bill of peace. Neither the principal dissent nor respondents have pointed to any evidence that such decrees presented any of the universal injunction's systemic problems, or that they were reserved for situations in which the defendant's conduct was patently unconstitutional and risked exceptional harm. It is precisely because the universal injunction is a new, potent remedy that it poses new, potent risks. Our observation in Grupo Mexicano rings true here. Even when sitting as a court in equity, we have no authority to craft a nuclear weapon of the law. Destiny, it feels like when the government does something illegal, such unconstitutional, instead of forcing the federal government to stop, you need each individual to sue the government for relief. Okay, stop asking me that. There has to be some way to do this that I just don't know about. And I don't know all the process and procedures, but there must be some other way to challenge the constitutionality of a thing. I just don't know what that is. If that is always like an APA challenge or what I don't know what that looks like. I'm not sure. But there must be some way to do it. Or maybe it's just in any case, instead of providing an injunction, like the court itself says, we actually have decided that this is unconstitutional, I guess. And then that's where that happens. Maybe. Okay. The principal dissent focuses on conventional legal terrain like the Judiciary Act of 1789 and our cases on equity. Justice Jackson, however, chooses a startling line of attack that is tethered neither to these sources nor, frankly, to any doctrine whatsoever. Waving away attention to the limits on judicial power as a mind-numbingly technical query, she offers a vision of the judicial role that would make even the most ardent defender of judicial supremacy blush. In her telling, the fundamental role of courts is to order everyone, including the executive, to follow the law, full stop. Justice Barrett here is fighting against Justice Jackson's dissent now. Quoting, I think, from her dissent, maybe. The function of the courts, both in theory and in practice, necessarily includes announcing what the law requires in suits for the benefit of all who are protected by the Constitution, not merely doling out relief to injured private parties. And, she warns, if courts lack the power to require the executive to adhere to law universally, courts will leave a gash in the basic tenets of our founding charter that could turn out to be a mortal wound. Rhetoric aside, Justice Jackson's position is difficult to pin down. She might be arguing that universal injunctions are appropriate, even required, whenever the defendant is part of the executive branch. What? No, from these quotes, Justice Jackson's position is very coherent. She's asking the same question that Chad is asking. How do you make the government follow the law? Does every single person have to sue? This is the main question that I guess I want to see addressed that I'm curious about. But she might be arguing that universal injunctions are appropriate, even required, whenever the defendant is part of the executive branch. If so, her position goes far beyond the mainstream defense of universal injunctions. See, for example, Frost 93, what is this, New York University Law Review or something? Nationwide injunctions come with significant costs and should never be the default remedy in cases challenging federal executive action. I bet that article would have good information about how to do that. As best we can tell, though, her argument is more extreme still because its logic does not depend on the entry of a universal injunction. Justice Jackson appears to believe that the reasoning behind any court order demands universal adherence, at least where the executive is concerned. In her law-declaring vision of the judicial function, a district court's opinion is not just persuasive, but has the legal force of a judgment. But, see Holland v. Bracken, it is a federal court's judgment, not its opinion, that remedies an injury. Okay. It is a federal court's judgment, not its opinion, that remedies an injury. So if you're suing somebody in a court of equity and you've been injured in some way, a federal court can issue a judgment against the defendant that remedies an injury, but an opinion about a case isn't necessarily a remedy. Okay, is what they're saying here, right? Once a single district court deems executive conduct unlawful, it has stated what the law requires, and the executive must conform to that view, ceasing its enforcement of the law against anyone, anywhere. Footnote 17. Think about what this position... Wait, hold on. Once a single district court deems executive conduct unlawful, it has stated what the law requires, and the executive must conform to that view, ceasing its enforcement of the law against anyone, anywhere. I would assume that's true. I would assume that's the case. She's about to say why you're retarded if you believe that. I feel like that must be true, but okay. What does she say? Think about what this position means. If a judge in the District of Alaska holds that a criminal statute is unconstitutional, can the United States prosecute a defendant under that statute in the District of Maryland? How can a federal law be enforceable in some parts of the federal territory of the United States, but not in other parts? Is that really the case? Can that really be the case? My understanding was there might be different venues for federal courts, but jurisdictionally, it's all essentially the same, and the laws are essentially shared. No? If a judge in the District of Alaska holds that a criminal statute is unconstitutional, can the United States prosecute a defendant under that statute in the District of Maryland? Perhaps Justice Jackson would instinctively say yes. It is hard to imagine anyone saying no. Am I just retarded? Maybe I'm just retarded. Okay, I guess. I am sorry. They can't imagine someone saying I am retarded. But why, on Justice Jackson's logic, does it not violate the rule of law for the executive to initiate a prosecution elsewhere? Among its many problems, Justice Jackson's view is at odds with our system of divided judicial authority. See, for example, this court's Rule 10A, identifying conflict in the decisions of the courts of appeals as grounds for granting certiorari, is also in considerable tension with the reality that district court opinions lack presidential force, even vis-a-vis other judges in the same judicial district. Huh. Okay. Rule 10A. What is, let's look that one up. Federal Rules Civil Procedure 10. Form of pleadings. 10A. Caption. Names of parties. Every pleading must have a caption. Is that what we're talking about? Every pleading must have a caption with the court's name, a title, a file number, and a Rule 7A designation. The title of the complaint must name all the parties. The title of other pleadings, after naming the first party on each side, may refer generally to other parties. No, we must be talking about some other type of rule. Is this like, are there like special Supreme Court rules? Supreme Court Rule 10. Oh, there is. Okay. Review on a writ of certiorari is not a matter of right, but of judicial discretion. A petition for a writ of certiorari will be granted only for compelling reasons. The following, although neither controlling nor fully measuring the court's discretion, indicate the character of the reasons the court considers. A United States Court of Appeals has entered a decision in conflict with the decision of another United States Court of Appeals on the same important matter. It has decided an important federal question in a way that conflicts with a decision by a state court of last resort, or has so far departed from the accepted and usual course of judicial proceedings, or sanctioned such a departure by a lower court as to cause for an exercise of this court's supervisory power. Wait, okay. In conflict with the decision of another United States Court of Appeals. Huh, okay. So maybe they're drawing a big distinction between the district court and the court of appeals, like the circuit appeals court. There's a big distinction there they're drawing, maybe? Okay. Okay. It is also, oh, okay. Wow, I'm really confused on this. I don't know. Hopefully it talks more about this. I don't get it. Where were we? If courts do not have the authority to require the executive to adhere to law universally, compliance with law sometimes becomes a matter of executive prerogative. Oh, sorry. No one disputes. Wait. Oh, no, we were up here. Okay. We will not dwell on Justice Jackson's argument, which is at odds with more than 2 centuries worth of precedent, not to mention the Constitution itself. We observe only this. Justice Jackson decries an imperial executive while embracing an imperial judiciary. Okay. Wait. Dumb. No one disputes that the executive has a duty to follow the law, but the judiciary does not have unbridled authority to enforce this obligation. In fact, sometimes the law prohibits the judiciary from doing so. See Marbury v. Madison, concluding that James Madison had violated the law, but holding that the court lacked jurisdiction to issue a writ of mandamus, ordering him to follow it. But see post, after 15 Jackson. If courts do not have the authority to require the executive to adhere to law universally, compliance with law sometimes becomes a matter of executive prerogative. Observing the limits on judicial authority, including, as relevant here, the boundaries of the Judiciary Act of 1789, is required by a judge's oath to follow the law. Justice Jackson skips over that part, because analyzing the governing statute involves boring legalese. She seeks to answer a far more basic question of enormous practical significance. May a federal court in the United States of America order the executive to follow the law? In other words, it is unnecessary to consider whether Congress has constrained the judiciary. What matters is how the judiciary may constrain the executive. Justice Jackson would do well to heed her own admonishments, or her own admonition, quote, everyone from the president on down is bound by the law. That goes for judges too. I'm very confused about this. I don't understand any of this. No one disputes that the executive has a duty to follow the law. How, if you have a duty to follow the law with no enforcement mechanism, does the duty to follow the law exist? I don't understand that. May a federal court in the United States of America order the executive to follow the law. In other words, it is unnecessary to consider whether Congress has constrained the judiciary. What matters is how the judiciary may constrain the executive. I don't understand this. I don't understand her argument here at all. Or I just don't understand, I guess, how the judiciary and the executive is supposed to work, but I don't understand that. Finally, the government must show a likelihood. Oh, did we get a footnote in there? I don't believe so. Okay. Finally, the government must show a likelihood that it will suffer irreparable harm absent a stay. This is the easiest argument, obviously. They're going to say that there's going to be huge harm because they can't even enforce their policy, so should be boring. When a federal court enters a universal injunction against the government, it improperly intrudes on a coordinate branch of the government and prevents the government from enforcing its policies against non-parties. That is enough to justify interim relief. The principal dissent disagrees, insisting that it strains credulity to treat the executive branch as irreparably harmed by these injunctions, even if they are overly broad. See also, that is so, the principal dissent argues, because the executive order is unconstitutional. Thus, the executive branch has no right to enforce it against anyone. The principal dissent's analysis of the executive order is premature because the birthright citizenship issue is not before us. The dissent worries that the citizenship clause challenge will never reach this court because if the plaintiffs continue to prevail, they will have no reason to petition for certiorari. And if the government keeps losing, it will have no incentive to file a petition here because the outcome of such an appeal would be preordained. But at oral argument, the Solicitor General acknowledged that challenges to the executive order are pending in multiple circuits. And when asked directly, when you lose one of those, do you intend to seek cert? The Solicitor General responded, yes, absolutely. And while the dissent speculates that the government would disregard an unfavorable opinion of the court, the Solicitor General represented the government will respect both the judgments and the opinions of this court. Were these oral arguments, was this the time when the Solicitor General said, we usually follow what the court says? Or were those a different set of oral arguments? Okay, oof. This opinion is hurting. This one hurts, okay? I'm an Amy Stan. I love Justice Barrett. This opinion is hurting me a lot, though. I hope that maybe Roberts wrote this one and forced her to put her name on it. But, geez. The principal dissent's analysis of the executive order is premature because the birthright citizenship issue is not before us. And because the birthright citizenship issue is not before us, we take no position on whether the dissent's analysis is right. The dissent is wrong to say, however, that a stay applicant cannot demonstrate irreparable harm from a threshold error without also showing that, at the end of the day, it will prevail on the underlying merits. That is not how the Enkin factors work. Wait, real quick, what is a threshold issue? When we say threshold issue, what does that mean? Like a new or edge case, or... In law, a threshold issue is a preliminary legal question that must be resolved before the court can address the main issues of a case. It often determines whether the court even has the power to hear the case. Okay, it's a threshold issue. Okay, so do they have the threshold to hear the case? Makes sense. Okay. The dissent is wrong to say, however, that a stay applicant cannot demonstrate irreparable harm from a threshold error without also showing that at the end of the day it will prevail on the underlying merits. That is not how the Incan factors work. For instance, when we are asked to stay an execution on the grounds of a serious legal question, we ask whether the capital defendant is likely to prevail on the merits of the issue before us, not whether he is likely to prevail on the merits of the underlying suit. Granting an application for a stay based on a question implicating the prisoner's standing to attempt to access DNA testing. The same is true when an applicant seeks a stay in other contexts, granting applications for stay because the organizational plaintiff's allegations were insufficient to support their standing. So too here. The question before us is whether the government is likely to suffer irreparable harm from the district court's entry of injunctions that likely exceed the authority conferred by the Judiciary Act. The answer to that question is yes. Quoting Maryland v. King, quoting Roberts, anytime a state is enjoined by a court from effectuating statutes enacted by representatives of its people, it suffers a form of irreparable injury. Now, this is an executive order, not a statute enacted by representatives of its people, but okay. And the balance of equities does not counsel against awarding the government interim relief. Partial stays will cause no harm to respondents because they will remain protected by the preliminary injunctions to the extent necessary and appropriate to afford them complete relief. Someone said, if it's unconstitutional in a single district, that's it. It would be odious to keep an unconstitutional law valid anywhere else. Well, but it sounds like that's not the case. I would have assumed that. So like if a federal court somewhere says, oh, this is actually unconstitutional or something, so we're not going to enforce it here, I guess the federal government can still enforce that law in other places. I didn't know that. I would just assume that that would automatically be challenged up to the Supreme Court and then a decision would like automatically happen there. But I don't know. I guess maybe I don't know how that process works, I guess. Why would it be irreparable? I think that it's just generally, that's kind of like a per quad. It's like assumed basically that if you're stopping the government from being able to appeal its action, or I'm sorry, to be able to carry out its policy, it's always considered irreparable injury, just period. You don't have to prove anything or assert any harms past it. It's just always assumed to be such. Not per quad, it's like per se or whatever. Some say that the universal injunction gives the judiciary a powerful tool to check the executive branch. Thomas, concurring side. Where are we at? Jesus. But federal courts do not exercise general oversight of the executive branch. They resolve cases and controversies consistent with the authority Congress has given them. When a court concludes that the executive branch has acted unlawfully, the answer is not for the court to exceed its power too. The government's applications to partially stay the preliminary injunctions are granted, but only to the extent that the injunctions are broader than necessary to provide complete relief to each plaintiff with standing to sue. The lower courts shall move expeditiously to ensure that, with respect to each plaintiff, the injunctions comport with this rule and otherwise comply with principles of equity. The injunctions are also stayed to the extent that they prohibit executive agencies from developing and issuing public guidance about the executive's plans to implement the executive order consistent with the Solicitor General's representation. Section 2 of the executive order shall not take effect until 30 days after the date of this opinion. Geez. Okay. So real quick, I'm just curious then. I never even imagined that this would matter, but so what exactly did this executive order say? Executive order trump birthright citizenship. Wow. So the government is going to have the right to enforce this executive order that I'm about to read, until the conclusion, I guess, of all these court cases against everybody except for the parties in these named cases. By the authority vested in me as president by the Constitution and the laws of the United States of America, it is hereby ordered, Section 1, purpose, the privilege of United States citizenship is a priceless and profound gift. The 14th Amendment states all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That provision rightly repudiated the Supreme Court of the United States' shameful decision in Dred Scott v. Sandford, which misinterpreted the Constitution as permanently excluding people of African descent from eligibility for United States citizenship solely based on their race. But the 14th Amendment has never been interpreted to extend citizenship universally to everyone born within the United States. The 14th Amendment has always excluded from birthright citizenship persons who were born in the United States, but not, quote, subject to the jurisdiction thereof, end quote. Consistent with this understanding, the Congress has further specified through legislation that a person born in the United States and subject to the jurisdiction thereof is a national and citizen of the United States at birth, 8 U.S.C. 1401, generally mirroring the 14th Amendment text. Among the categories of individuals born in the United States and not subject to the jurisdiction thereof, the privilege of U.S. citizenship does not automatically extend to persons born in the United States. 1, when that person's mother was unlawfully present in the United States and the father was not a U.S. citizen or a lawful permanent resident at the time of said person's birth. So that means that if a woman is in this country illegally and does not have an American husband, while unlawfully present, then and she has a child here, that child is not granted U.S. citizenship. And then 2, when that person's mother's presence in the United States at the time of said person's birth was lawful but temporary, such as, but not limited to, visiting the U.S. under the auspices of the Visa Waiver Program, or visiting on a student, work, or tourist visa, and the father was not a U.S. citizen or lawful permanent resident at the time of said person's birth. It is the policy of the United States that no department or agency of the U.S. government shall issue documents recognizing. So this is a revocation, basically, then of. So this is all birthright citizenship. So 30 days from now, I'm guessing, not from the enactment of the statute, but 30 days from now, I guess, birthright citizenship in the United States is gone until these court cases are resolved, and if the Supreme Court decides to make a broader ruling on this executive order, I guess. Damn. Nothing is sort of. Oh. How far back can they revoke this? I believe this is just going forward. This isn't like retroactive. I think, right? It is the policy of the United States that no department or agency of the United States government shall issue documents recognizing United States citizenship or accept documents issued by state, local, or other governments or authorities purporting to recognize U.S. citizenship to persons, 1, when that person's mother was unlawfully present in the U.S. and the person's father was not a U.S. citizen or lawful permanent resident, and 2, when that person's mother's presence in the U.S. was... subsection A of this section shall only apply to persons, or shall apply only to persons who are born within the United States after 30 days from the date of this order. Okay. So it's not retroactive. It's just... but it would go 6 months back, I guess. Damn. Well, cool. That we can just... I guess we were just axed birthright citizenship for now. Cool that Amy pulled a Roberts and didn't even address the main issue. I mean, it makes sense that they're not addressing the main issue now. That's fine, because the court cases haven't even, I don't even know if the court cases have, like, if they've gotten very far in them yet. I don't think they have, so that makes sense, I guess. We're just ordering over preliminary stuff right now. Okay, well, Justice Thomas writing, with whom Justice Gorsuch joins, concurring. Thomas, I believe, is one of the most schizophrenic writers. Gorsuch, in my opinion, has been one of the best, so let's see what these guys say. The court today holds that federal courts may not issue so-called universal injunctions. I agree and join in full, as the court explains. The Judiciary Act of 1789, the statute that authorizes the federal courts to issue equitable remedies, does not permit universal injunctions. It authorizes only those remedies traditionally available in equity, and there is no historical tradition allowing courts to provide relief that extends beyond the parties. That conclusion is dispositive. That means that dispositive means that's all you need to prove it, it's done, right? As I have previously explained, if district courts have any authority to issue universal injunctions, it must come from some specific statutory or constitutional grant. But the Judiciary Act is the only real possibility, and serious constitutional questions would arise even if Congress purported to one day allow universal injunctions. Somebody donated and said, Destiny, what do you think about Represent Us and the forward party's prioritization of voting, lobbying, and community reform? I feel like we only need priorities insulating the government. I don't care about that shit. I don't think that's that important. I think it's a 10-year-old issue that I don't think is irrelevant, but what if someone is born in the U.S. during this time and then gets deported and they lose the case? Would that mean we have deported a U.S. citizen? Well, I have no fucking idea. I have no idea. I have no idea. So if, let's say that you're born and ordinarily be granted birthright citizenship, but now you're not, as the court case is ongoing. Let's say that the plaintiffs win the court case and the Supreme Court decides that this EO is unconstitutional. Are they going to retroactively give citizenship to people that were here? I have no clue. They'd be stateless people. I don't think we're running into the stateless people issue yet, because, like, I'm trying to think of an example of somebody giving birth here in the U.S. where they wouldn't just inherit the citizenship or nationality of their parent. Like, if somebody illegally came over from Mexico and then gave birth here, they wouldn't have U.S. citizenship, but they'd still be granted Mexican citizenship, right? I would have to see what the Mexican citizenship requirements are, but I imagine it must be the case that if you're born to a citizen parent, you must inherit that citizenship. That'd be my guess, but I don't know. Why do you assume that there must be? Because that just seems like intuitive to me. So, like, you're telling me that if you have two German parents and then you go to, and your parents are in Sweden or whatever, and they have a kid there, that the child's not a German citizen? They don't inherit citizenship from their parents at all? That seems highly unlikely to me. But I mean, I could be wrong, but. And my guess would be that's probably the same for New World countries as well. But, okay. I write separately to emphasize the majority's guidance regarding how courts should tailor remedies specific to the parties. Courts must not distort the rule that injunctive relief should be no more burdensome to the defendant than necessary to provide complete relief to the plaintiffs. Otherwise, they risk replicating the problems of universal injunctions under the guise of granting complete relief. As the court recognizes, the complete relief principle operates as a ceiling. In no circumstance can a court award relief beyond that necessary to redress the plaintiff's injuries. Well, what about punitive relief? Or is that something that can only be awarded by a jury? Does a jury count as like the court? I have no idea. Complete relief is not a guarantee. It is the maximum a court can provide. This limitation follows from both Article 3 and traditional equitable practice. Because Article 3 limits courts to resolving specific cases and controversies, see U.S. Constitution, Article 3, Section 2, it requires that any remedy be tailored to redress the plaintiff's particular injury. And equitable remedies historically operate on a plaintiff-specific basis. Accordingly, any remedy must, of course, be limited to the inadequacy that produced the injury in fact that the plaintiff has established. Courts, therefore, err insofar as they treat complete relief as a mandate. Some judges have read our precedents to suggest that courts should provide plaintiffs whatever remedy is necessary to give them complete relief. Injunctions should be crafted to provide complete relief to the plaintiffs. Courts tailor their injunctions to provide complete relief to the parties, no less and no more. But that reading misunderstands the complete relief principle. Punitive relief is a remedy at law, not equity, and is unaffected by this decision. Okay. Okay, where am I? This principle reflects that equitable rule that This principle reflects the equitable rule that courts generally may administer complete relief between the parties. It is an important aim of the law of remedies to put the plaintiff in her rightful position. But to say that a court can award complete relief is not to say that it should do so, and in some circumstances, a court cannot award complete relief. As the court today affirms, any relief must fall within traditional limits on a court's equitable powers. Courts must ask whether the relief plaintiffs seek was traditionally accorded by courts of equity, and they must ensure that any injunctions comport with both the complete relief principle and other principles of equity. For example, courts may need to weigh considerations such as equity's concern with justice, also for the defendant. In some cases, traditional equitable limits will require courts and plaintiffs to make do with less than complete relief. This court's decision in Frothingham v. Mellon, decided with Massachusetts v. Mellon, exemplifies this constraint. Appellant Frothingham, what a name, Frothingham, sought to enjoin the execution of a Federal Appropriation Act on the grounds that the act exceeded the government's authority and that its execution would improperly increase her tax burden. On a maximalist view of the complete relief principle, Frothingham would have been entitled to a national injunction had her claim been meritorious. After all, a prohibition on using her tax money for the statute would have been wholly ineffectual in remedying the injury caused by unlawful federal spending given the fungibility of money. The government would still have been free to execute the statute as long as it labeled the underlying funds as coming from other taxpayers. A court thus would have needed to enjoin all spending under the statute to provide effective relief. Well, this sounds fucking retarded. I'm sorry, hold on. The question you found me decided with master exemplifies constraint. Appellant Frothingham sought to enjoin the execution of a Federal Appropriation Act on the grounds that the act exceeded the government's authority and that its execution would improperly increase her tax burden. On a maximalist view of the complete relief principle, Frothingham would have been entitled to a national injunction had her claim. Wouldn't a narrowly tailored injunction just make it so that her tax burden wouldn't be increased? I don't understand this at all. But, okay. The government would still have been free to execute the statute as long as the brain. Okay, a court with this, but this court rejected Frothingham's request for such an injunction as beyond the preventative powers of a court of equity. Among other reasons, it emphasized that an individual taxpayer's interest in the money of the Treasury was comparatively minute, minute and indeterminable, and that the petitioner had not suffered any direct injury, but rather was suffering in some indefinite way in common with people generally. To be sure, what counts as complete relief can be a difficult question. Does SCOTUS even have the authority under this ruling to rule something unconstitutional beyond the plaintiff who sued? I think they still do. I don't think that impacts anything. I think they can still think that things are unconstitutional. Fuck. Wait, hold on one second. No. Wait. Wait, hold on one second. No, never mind. Sorry. Just kidding. Okay, just kidding. Ignore me. To be sure, what counts as complete relief. Oh, wait. Asterisks. Although courts now treat Frothingham primarily as a case about taxpayer standing, its analysis, in fact, intertwined concepts of equity, remedies, and the judicial power. To be sure, what counts as complete relief can be a difficult question. Many plaintiffs argue that only sweeping relief can redress their injuries, and I do not dispute that there will be cases requiring an indivisible remedy that incidentally benefits third parties, such as injunctions barring public nuisances, but such cases are by far the exception. An indivisible remedy is appropriate only when it would be all but impossible to devise relief that reaches only the plaintiffs. Such impossibility is a high bar. For example, the court today readily dispatches with the individual and associational respondent's position that they require a universal injunction, notwithstanding their argument that a plaintiff-specific injunction would be difficult to administer and would subject the association's members to the burden of having to identify and disclose to the government their membership. As the court recognizes, prohibiting enforcement of the executive order against the child of an individual pregnant plaintiff is all that is required to give that plaintiff complete relief. Courts may not use the complete relief principle to revive the universal injunction. For good reason, the court today puts an end to the increasingly common practice of federal courts issuing universal injunctions. The court also makes clear that the complete relief principle provides a ceiling on federal courts' authority, which must be applied alongside other principles of equity, and are holding that universal injunctions are impermissible. Lower courts should carefully heed this court's guidance and cabin their grants of injunctive relief in light of historical equitable limits. If they cannot do so, this court will continue to be duty-bound to intervene. What was the point of writing this? He really wanted that ceiling, I guess. Okay. Alito, our other friendly schizo judge. What do we got? Justice Alito, with whom Justice Thomas joins, concurring. I join the opinion of the court, but write separately to note two related issues that are left unresolved and potentially threaten the practical significance of today's decision: the availability of third-party standing and class certification. First, the court does not address the weighty issue of whether the state plaintiffs have third-party standing to assert the citizenship clause claims of their individual residents. The government's applications to partially stay the preliminary injunctions are granted, but only to the extent that the individual are withstanding to sue. Okay. Third-party standing, I guess, my guess is going to be here is that, like, you need standing to sue can I claim that I have standing on your behalf to sue for you? And the states are asserting, I guess, or claiming to have third-party standing. Actually, I don't even know if the state is suing on behalf of the citizens, or if the state is just suing on behalf of itself and the undue burden that it would be placed on it if the citizens were to be, but I'm not sure. Hi, if it's left to states, what would happen to someone who moves? Like if a state doesn't recognize them as a U.S. citizen, but they were born in a state that has it, would they not be allowed to vote? Well, so recognizing a U.S. citizen is not, that's the purview of the federal government, I believe, not of a state. The federal government is what deals with citizenship. Ordinarily, a litigant must assert his or her own legal rights and interests and cannot rest a claim to relief on the legal rights or interests of third parties. In limited circumstances, however, the court has permitted a party to assert the rights of a third party. Again, I don't believe that plaintiffs here were suing on behalf of their citizens. I thought they were suing on behalf of the state, because it would be burdened by all of the paperwork and everything else. Maybe that's what that was, or at least I thought that was one of the arguments that was addressed earlier, or that was proffered earlier. Admittedly, the court has not pinned down the precise circumstances in which third-party standing is permissible, and commentators have emphasized the need for greater doctrinal coherence. But at a minimum, we have said that a litigant seeking to assert the legal rights or interests of others must demonstrate ordinary Article 3 standing for itself and answer the additional threshold question of whether it has standing to raise the rights of others. This latter requirement, as we have explained, entails a showing that the litigant has a close relationship to the right holder and that there is some hindrance to the right holder's ability to protect his own interests. So long as third-party standing doctrine remains good law, federal courts should take care to apply these limitations conscientiously, including against state plaintiffs. That is especially so in cases such as these, in which the parties claiming third-party standing, in this case the states, are not directly subject to the challenge policy in the relevant respect and face, at most, collateral injuries. Are not directly subject to the challenge policy. Unless I'm missing something, this is just not true, no? Because part of the executive order says oh, no, wait, actually, hold on, maybe not. Wait 1 second. Never mind, I thought this barred states from issuing stuff, but it doesn't. So the Section 2 of the policy for this executive order is, it is the policy of the United States that no department or agency of the U.S. government shall issue documents recognizing U.S. citizenship or accept documents, so that's just the federal government, or accept documents issued by state, local, or other governments or authorities purporting to recognize U.S. citizenship to persons. Okay, so this doesn't actually, I don't know how states would have standing to sue at all then for this, unless they were doing it as third-party representatives of their states. Okay. That is especially so in cases such as these, in which the parties claiming third-party standing are not directly subject to the challenge policy. Okay. Today's decision only underscores the need for rigorous and even-handed enforcement of third-party standing limitations. The court holds today that injunctive relief should generally extend only to the suing plaintiff. That will have the salutary effect of bringing an end to the practice of runaway universal injunctions, but it leaves other questions unanswered. Perhaps most important, when a state brings a suit to vindicate the rights of individual residents and then procures injunctive relief, does the injunction bind the defendant with respect to all residents of that state? If so, states will have every incentive to bring third-party suits on behalf of their residents to obtain a broader scope of equitable relief than any individual resident could procure in his own suit. Left unchecked, the practice of reflexive state third-party standing will undermine today's decision as a practical matter. One of the things that he said earlier, though, is there's a second part to the test, and that was, is there something that's prohibiting the other party from bringing a suit themselves? So I don't know if that would be as broad as it says there, but that's not it, I guess. Okay, where are we at? Second, today's decision will have very little value if district courts award relief to broadly defined classes without following Rule 23's procedural protections for class certification. The class action is a powerful tool, and we have accordingly held that class certification is proper only if the trial court is satisfied, after a rigorous analysis, that the prerequisites of Rule 23A have been satisfied. These requirements are more than a mere pleading standard, and a hasty application of Rule 23 of the Federal Rules of Civil Procedure can have drastic consequences, creating potential unfairness for absent class members and confusion and pressure to settle for defendants. Recognizing these effects, Congress took the exceptional step of authorizing interlocutory review of class certification. Putting the kibosh on universal injunctions does nothing to disrupt Rule 23's requirements. Of course, Rule 23 may permit the certification of nationwide classes in some discrete scenarios, but the district courts should not view today's decision as an invitation to certify nationwide classes without scrupulous adherence to the rigors of Rule 23. Otherwise, the universal injunction will return from the grave under the guise of nationwide class relief, and today's decision will be of little more than minor academic interest. Lax enforcement of the requirements for third-party standing and class certification would create a potentially significant loophole to today's decision. Federal courts should thus be vigilant against such potential abuses of these tools. I do not understand the court's decision to reflect any disagreement with these concerns, so I join its decision in full. I do not understand the court's decision to reflect any disagreements with these concerns, so I join its decision in full. Well, okay. I feel like that sounds strange, but all right. Testing has to be both parents, though, right? With the Trump lawsuit, I think with the Trump EO, as long as one person is a citizen, I think the child still gets citizenship. As long as the parent is a green card holder or a U.S. citizen, you only need one parent to inherit citizenship with this executive order. Okay. That was Alito. Kavanaugh. Is it effective now, or does it have to pass Congress? Nope, it's effective right now. Trump talking live. Maybe I'll watch after. So as of right now, birthright citizenship does not exist in the United States. We've gotten rid of that for now until the court case is over. We'll see how they rule. The plaintiffs here sought preliminary injunctions against enforcement of the president's executive order on birthright citizenship. The district courts granted universal preliminary injunctions, that is, injunctions prohibiting enforcement of the executive order against anyone. Under the court's holding today, district courts issuing injunctions against or under the authority afforded by the Judiciary Act of 1789 may award only plaintiff-specific relief. I join the court's careful and persuasive opinion, which will bring needed clarity to the law of remedies. To be sure, in the wake of the court's decision, plaintiffs who challenge the legality of a new federal statute or executive action and request preliminary injunctive relief may sometimes seek to proceed by class action under Federal Rule of Civil Procedure 23b2 and ask a court to award preliminary class-wide relief that may, for example, be statewide, region-wide, or even nationwide. And in cases under the Administrative Procedure Act, plaintiffs may ask a court to preliminarily set aside a new agency rule. Okay, so it sounds like this is the proper way that you would challenge new executive orders, basically, right? But importantly, today's decision, or let's read footnote 1. In addition, as the court notes, an injunction granting complete relief to plaintiffs may also, as a practical matter, benefit non-parties. Can this affect naturalized citizens? No, this is only for people going forward. Destiny, not yet, in 30 days. Okay, that might be true. I don't know if that's the case because the executive order said 30 days from the EO. I don't know if these guys said 30 days from this court decision or how that works, but I don't know if it was retroactive or not. But importantly, today's decision will require district courts to follow proper legal procedures when awarding such relief. Most significantly, district courts can no longer award preliminary, nationwide, or class-wide relief, except when such relief is legally authorized. I don't know why Gorsuch puts preliminary here when it's all injunctions, not just preliminary ones. And that salutary development, or no, Kavanaugh, this is Kavanaugh, not Gorsuch writing, my bad. And that salutary development will help bring substantially more order and discipline to the ubiquitous preliminary litigation over new federal statutes and executive actions. I write separately simply to underscore that this case focuses on only one discrete aspect of the preliminary litigation relating to major new federal statutes and executive actions, namely, what district courts may do with respect to those new statutes and executive actions in what might be called the interim before the interim. Does a district court refer specifically to the first court in a federal district? Or like, are circuit courts also considered district courts? Or is a circuit court of appeals not a district court? Like, that's the circuit court of appeals that the district courts are a part of. Is a circuit court a district court? The federal court system has three main levels: district courts, trial courts, circuit courts, which are the first level appeals. Okay, no, it's not. Okay, so they are separate things. Gotcha. Although district courts have received much of the attention and criticism in debates over the universal injunction issue, those courts generally do not have the last word when they grant or deny preliminary injunctions. The courts of appeals, and this court, so your circuit courts, Court of Appeals and circuit courts, and this court can, and regularly do, expeditiously review district court decisions awarding or denying preliminary injunctive relief. The losing party in the district court, the defendant against whom an injunction is granted, or the plaintiff who is denied an injunction, will often go to the Court of Appeals to seek a temporary stay or injunction. And then the losing party in the Court of Appeals may promptly come to the court, to this court, the Supreme Court, with an application for a stay or injunction. This court has therefore often acted as the ultimate decider of the interim legal status of major new federal statutes and executive actions. After today's decision, that order of operations will not change. In justiciable cases, this court, not the district courts or courts of appeals, will often still be the ultimate decision maker as to the interim legal status of major new federal statutes and executive actions, that is, the interim legal status for the several-year period before a final decision on the merits. The court's decision today focuses on the interim before the interim, the preliminary relief that district courts can award and courts of appeals can approve for the generally weeks-long interim before this court can assess and settle the matter, for the often years-long interim before a final decision on the merits. To appreciate the broader context surrounding today's decision, it is important to understand this court's role in preliminary litigation of this sort. The basic scenario in these kinds of applications to this court is by now familiar. Congress passes a major new statute, or the executive branch issues a major new rule or executive order. The litigation over the legality of the new statute or executive action winds its way through the federal courts, and that litigation may meander on for many months or often years before this court can issue a final ruling deciding the legality of the new statute or executive action. In the meantime, various plaintiffs may seek preliminary injunctions, sometimes in many different district courts, and a government defendant against whom a preliminary injunction is granted, or a plaintiff who is denied a preliminary injunction, may seek a temporary stay or injunction in the Court of Appeals and then in this court. That preliminary injunction litigation, which typically takes place at a rapid-fire pace long before the merits litigation culminates several years down the road, raises a question. What should the interim legal status of the significant new federal statute or executive action at issue be during the several-year period before this court's final ruling on the merits? That interim status question is itself immensely important. This is true. So this is like kind of answering the question, I think, of like, well, what happens to people that are born while the court case is ongoing, depending on whether or not an injunction is granted or not granted, right? Like, what's the legal status of the rule or the law from Congress, right? That interim status question is itself immensely important. The issue of whether a major new federal statute or executive action is enforceable during the several years while the parties wait for a final merits ruling raises a separate question of extraordinary significance to the parties and the American people. The interim status issue, in turn, raises two other critical questions. Should there be a nationally uniform answer on the question of whether a major new federal statute or executive action can be legally enforced in the often years-long interim period until this court reaches a final decision on the merits, and if so, who decides what the nationally uniform interim answer is? It has to be no. There's no way they're going to say that they can issue a nationally uniform interim answer, but they don't have the authority to do universal injunctions or whatever, right? They can't possibly have that double position, no? Hold on, I need to soy the fuck out. Let me get a soy on 1 second. Oh. Okay. First, in my view, there often, perhaps not always, but often, should be a nationally uniform answer on whether a major new federal statute, rule, or executive order can be enforced throughout the United States during the several-year interim period until its legality is finally decided on the merits. Consider, well, that's what the point of a universal injunction is, right? Consider just a few of the major executive actions that have been the subject of intense preliminary injunction or other pre-enforcement litigation in the past 10 years or so under presidents of both political parties. They range from travel bans to birthright citizenship, from the Clean Power Plan to student loan forgiveness, from the OSHA vaccine mandate to the service of transgender individuals in the military, from Title IX regulations to abortion drugs. And the list goes on. Those executive actions often are highly significant and have widespread effects on many individuals, businesses, governments, and other organizations throughout the United States. Often, it is not especially workable or sustainable or desirable to have a patchwork scheme, potentially for several years, in which a major new federal statute or executive action of that kind applies to some people or organizations in certain states or regions, but not to others. The national reach of many businesses and government programs, as well as the regular movements of the American people into and out of different states and regions, would make it difficult to sensibly maintain such a scattershot system of federal law. Second, if one agrees that the years-long interim status of a highly significant new federal statute or executive action should often be uniform throughout the United States, who decides what the interim status is? The answer, typically, will be this court, as has been the case both traditionally and recently. This court's actions in resolving applications for interim relief help provide clarity and uniformity as to the interim legal status of major new federal statutes, rules, and executive orders. In particular, the court's disposition of applications for interim relief often will effectively settle, de jure or de facto, the interim legal status of those statutes or executive actions nationwide. The decision today will not alter this court's traditional role in those matters. Going forward, in the wake of a major new federal statute or executive action, different district courts may enter a slew of preliminary rulings on the legality of that statute or executive action, or alternatively, perhaps a district court or courts will grant or deny the functional equivalent of a universal injunction, for example, by granting or denying a preliminary injunction to a putative nationwide class under Rule 23b-2, or by preliminarily setting aside or declining to set aside an agency rule under the APA. No matter how the preliminary injunction litigation on those kinds of significant matters transpires in the district courts, the courts of appeals, in turn, will undoubtedly be called upon to promptly grant or deny temporary stays or temporary injunctions in many cases. And regardless of whether the district courts have issued a series of individual preliminary rulings, or instead have issued one or more broader class-wide or set-aside preliminary rulings, the losing parties in the courts of appeals will regularly come to this court in matters involving major new federal statutes and executive actions. The footnote, by statute, some litigation may start in a court of appeals or three-judge district court and then come directly to this court. If there is no class-wide or set-aside relief in those kinds of nationally significant matters, then one would expect a flood of decisions from lower courts, after which the losing parties on both sides will probably inundate this court with applications for stays or injunctions. And in cases where class-wide or set-aside relief has been awarded, the losing side in the lower courts will likewise regularly come to this court if the matter is sufficiently important. When a stay or footnote 3, that scenario explains why it would not make much sense for this court to apply different standards to 1, an application for an injunction, and 2, an application for a stay of an injunction. Suppose a district court in Circuit A enjoins a new executive action, and the Court of Appeals in Circuit A then declines to stay the injunction. Meanwhile, a district court in Circuit B does not enjoin that new executive action, and the Court of Appeals in Circuit B also declines to enjoin it. Both cases come to the court on applications for interim relief, one seeking a stay of injunction and one seeking an injunction. It would not be particularly rational to deny a stay and leave the injunction in place in Circuit A, and then turn around and deny an injunction in Circuit B on account of a purportedly higher standard for this court to grant injunctions rather than stays. The standards should mesh so that this court can ensure uniformity without regard to the happenstance of how various courts of appeals and district courts ruled. To obtain an interim stay or an injunction, an applicant must show... that was footnote 3. Destiny, but the Trump admin will just never appeal a preliminary injunction then. Yeah. Right? Let me think of how that makes sense. So let's say that the government wants to force you to eat candy bars, and then somebody sues the government in District A, and the government wins. The other person could appeal the case, and then we would get that up to the Supreme Court that way. But in another circuit, let's say that the government loses, they would just never appeal that case. Yeah, how do you get over that, Bert? How do you overcome that bias? he kind of passes over that. Suppose a district court in Circuit A. So, okay. So, like, let's do this example here. Suppose a district court in Circuit A stops a new executive action saying everybody has to eat candy bars. And the Court of Appeals in Circuit A declines to stay the injunction. And the Court of Appeals says, yeah, that's like, we're going to stop you from the new candy bar eating executive order. Meanwhile, a district court in Circuit B says that, no, actually, it's fine. You can be forced to eat candy bars. And then the Court of Appeals in Circuit B also declines to enjoin it. Both cases come to this court on applications for interim relief. Why would both of those cases, assuming the same defendant, how would both of those cases go to the Supreme Court? I feel like this is a very specific question. Suppose the district court in Circuit A enjoins a new... If the government loses in some place, they just wouldn't appeal it. Yeah, why would they? Then you just wouldn't enforce it over there. Or you would look for a universal ruling from the Supreme Court in a case that you won. Will the birthright citizenship thing only affect you if it's both parents? I don't understand what you mean. Right now, there is no or in 30 days, I guess. I don't know if it's 30 days right now. There will be no more birthright citizenship. You need to have at least one citizenship granted parent or one lawful permanent resident parent in order to in order to have citizenship, basically. Can they deport the baby then? Yeah. The baby and the mom, right? I don't understand this argument. Maybe it gets addressed somewhere else. How many generations back is birthright citizenship revoked? They're not revoking it. Like, they're not revoking citizenship for anybody. Not yet. They're just no more new citizenship given for birthright citizenship. When a stay or injunction application arrives here, this court should not and cannot hide in the tall grass. Oh, sorry. And in cases where classified or set-aside relief has been awarded, the losing side and the lower courts will likewise regularly come to this court if the matter is sufficiently important. When a stay or injunction application arrives here, this court should not and cannot hide in the tall grass. When we receive such an application, we must grant or deny. To obtain an interim, I'm reading the footnote. To obtain an interim stay or an injunction, an applicant must show 1, a reasonable probability that 4 justices will consider the issue sufficiently meritorious to grant certiorari, 2, a fair prospect that a majority of the court will vote to reverse the judgment below, and 3, a likelihood that irreparable harm will result from the denial. The court may also consider the balance of the equities and relative harms to the parties. Okay, wait. Let me explain this. I'm sorry, because it's important to understand this for the 20 of you that care about this procedure stuff, okay? This is why this is bullshit, in my opinion. But maybe this will be addressed, okay? So what Kavanaugh is saying is that, okay, Kavanaugh, he's saying, yes, we kind of have to figure out what we're going to do with a federal rule or an executive rule or a congressional law while we're waiting for the court to rule on it. Like, that's fair, right? The Supreme Court needs to be able to make some kind of nationwide universal statement about it, okay? But we're getting rid of universal injunctions, so how would that work? So what Kavanaugh is saying is that, well, there'll probably be a lot of challenges in different district courts that would get through Court of Appeals, and then finally, those challenges would come up to us, and then it would be on us to make a ruling that would give way to kind of like a nationwide ruling that would impact every federal court across the nation until the court case is basically completed. And so to further that, he says, suppose that a district court in Circuit A, so we'll say like a federal court in California, stops this new Trump executive action. And then let's say that a court of appeals in my circuit in Florida, I'm sorry. Let's say that in California, they stop the executive action. And then let's say that in California, it's appealed up to the circuit court. And let's say that the circuit allows that stop to stay. They say, fine, yeah, we're blocking that, okay? The circuit, so the appeals court, the federal appeals court. And then let's say over in Florida, in my state, let's say the opposite happens. Let's say that in Florida, they say, actually, no, we're going to let this stand. And then the circuit court is also going to say, yeah, we're going to let this stand. Both of these cases would be appealed up to the Supreme Court, and the Supreme Court would have before it an injunction that was granted, and then a stay for an injunction that was granted, right? So the Supreme Court's going to have to decide, well, are we going to let the injunction stand or not? Whatever we decide is probably going to have to be the same for both. We're not going to say to one circuit, okay, you guys that blocked the action, you're good, and you guys that decided to block of the action, you're also good, right? The Supreme Court will make one decision, right? But the issue is that it's assumed that all of these cases will get up to the Supreme Court, all right? Now, let's say that we're not an idiot, and let's say that we are the government. Let's say that we're the government, and let's say that we're sued in 10 different states, okay? Let's say that we win in 5 districts. Let's say that we lose in the other 5 districts. Well, if we lose a case, we're never appealing that. We'll just let that one, fuck it, we lost that, okay? If we lose a case, we're not going to appeal. We're not appealing that. Fuck it, we lost it. And then in the ones where we won, well, fuck it, we'll let those fuckers appeal. And then when we win, and then they appeal up to the circuit court, okay, well, we're going to fight here. And then if we lose up there, well, fuck it, maybe we'll just let that one stand, fuck it. But if we win, well, then fuck it. We'll let those guys appeal to the Supreme Court. So now what happens is the only cases that would ever percolate, it's the word that the Solicitor General likes to use, the only cases that would make it to the Supreme Court are going to be ones that losers are appealing, where us, the government, has won in the district court and then prevailed in the circuit court, and now we'll let the losers appeal it up to the Supreme Court. So the only thing before the Supreme Court is are these cases that are all pointing in one direction. And I don't know how you counter that. What is the counter to that? Like, he's not giving a specific example here, because in what world is somebody appealing all the way up to the Supreme Court when you have 2 contrary rulings? You're not going to appeal both, right? Or why not just appeal, let them appeal? Don't appeal cases that you lose. If you lose, then fuck it. Because the worst you can lose at is the district court level, right? And if you lose at the district court, well, then fuck it. Fuck them. Fuck that circuit. And then in places where you win and they try to get an injunction against you, and then the stays issued up at the circuit court, well, then you fight at the circuit court. And then if you lose in the circuit court, well, fuck them. Then fuck that circuit, I guess. And then if you win a circuit court, we won. And then if they appeal that, well, let's go to the Supreme Court and fight. So you're only going to the Supreme Court with cases where you've won at the district and circuit level. So why would you do that? Why, that feels like it's heavily in favor when it's the same defendant, the government, right, across all the districts and circuits. I don't understand how those cases would ever get to. Leon's Law says, well, these cases are all from the government appeal, so it seems to be working. These cases are where the government lost in all 3 cases, though. And the government lost on their request for a stay in all 3 cases, though, right? So, I mean, I don't know. I guess maybe this will be addressed later on. Who knows? We'll see. but you want to lose when you know the Supreme Court will fix it. Well, but you don't know what the Supreme Court will do. But I'm saying that why would you risk losing? Because imagine you've lost 5 cases and then you've won 5 cases. I don't want to appeal all those up to the Supreme Court. I'm going to let the 5 that I win, I'll let those losers appeal it up to the Supreme Court. Because then when the Supreme Court makes a decision on the case that I've won, and I've already won these in the lower courts, so the percolating facts are probably in my favor, ideally, right? That means that I'm more likely to get a ruling from the Supreme Court that will be effective throughout the nation, which would supersede the district and circuit courts where I lost, right? Like that's, do you understand the issue? I feel like that's, unless I'm missing some other way that those other cases would get to the Supreme Court, like I have a chance of selectively basically trying cases at the Supreme Court level where I've already won in both of the lower courts, and now I can get a ruling at the nationwide level that will supersede the districts and the circuits where I've already lost, right? If the government loses in Circuit A, can't the cases in Circuit B, C, and D just cite the case in Circuit A? I mean, you can cite it weekly, but generally speaking, circuits are their own circuits, and they don't like to hear, like, if you cite it, like, if I'm in Florida and I'm like, actually, the Ninth Circuit said this, then the judge would say, well, okay, well, eat shit and move to California and then sue them there. This is the 11th Circuit, motherfucker. I don't care what the Ninth Circuit said. They can listen. I mean, they can look for guidance, or they can look to other circuits for guidance, but they're not even bound. They're not even technically, I don't think a district court judge is bound necessarily even by their own circuit rulings, although they like to look to those more, I think. Okay. When we receive an application, we must grant or deny. And when we do, that is, when this court makes a decision on the interim legal status of a major new federal statute or executive action, that decision will often constitute a form of precedent, de jure or de facto, that provides guidance throughout the United States during this years-long interim period until a final decision on the merit. It is sometimes suggested, however, that this court should adopt a policy of presumptively denying applications for stays or injunctions, even applications involving significant new federal statutes or executive actions, regardless of which way the various lower courts have ruled. That suggestion is flawed, in my view, because it would often leave an unworkable or intolerable patchwork of federal law in place. And even in cases where there is no patchwork, for example, because an application comes to us with a single nationwide class action injunction, what if this court thinks the lower court's decision is wrong? On student loan forgiveness or the Clean Power Plan or mifepristone? Was that the abortion drug or something? I don't remember. Or the travel bans, for example. Should we have a rule of presumptively denying relief, thereby allowing erroneous injunctions or erroneous denials of injunctions of major new statutes and executive actions to remain in place for several years, and thus severely harming the government and would-be beneficiaries of, or regulated parties under, those new statutes and executive actions? I think not, and this court's actions over the years reflect that this court thinks not. This is a concurring opinion, right? It is. Okay. How does he? Okay. Unless and until this court grants or denies an application for stay or injunction, tremendous uncertainty may surround the interim legal status of the new federal statute or executive action throughout the country. The statute or executive action may be in effect in some places, but not others, for some businesses, but not others, for some Americans, but not others. That temporary geographic, organizational, and individual variation in federal law might not warrant this court's intervention in run-of-the-mill cases, which is why it makes sense that this court denies applications for interim relief when the court is unlikely to later grant certiorari, meaning that like the case isn't even important enough for them to hear the case, so why would they hear a stay or an injunction based on the case? But in cases involving major new federal statutes or executive actions, uniformity is often essential, or at least sensible and prudent. In those kinds of cases, disuniformity, even if only for a few years or less, can be chaotic. And such chaos is not good for the law or the country. Nick says, Destiny, assuming these mean what they mean, do you think them presidential hopefuls should vow to spam executive action since Trump's SCOTUS has kind of made it meta? If not, this will be overturned when SCOTUS loops back left in 12 years. We're stuck on this patch for a while. Who knows? Like, when I get to the end of this, I'll have a better opinion. We'll see. One of this court's roles in justiciable cases is to resolve major legal questions of national importance and ensure uniformity of federal law. So a default policy of offloading to lower courts the final word on whether to green light or block major new federal statutes and executive actions for the several-year interim until a final ruling on the merits would seem to amount to an abdication of this court's proper role. Wait, how does he join the majority opinion? It's coming. Or I'm just not understanding this at all. I don't know. Some might object that this court is not well equipped to make those significant decisions, namely decisions about the interim status of a major new federal statute or executive action on an expedited basis. But district courts and courts of appeals are likewise not perfectly equipped to make expedited preliminary judgments on important matters of this kind. Yet, they have to do so, and so do we. By law, federal courts are open and can receive and review applications for relief 24/7, 365. See 28 U.S.C. Section 452. All courts of the United States shall be deemed always open for the purpose of filing proper papers and making motions and orders. And this court has procedural tools that can help us make the best possible interim decision in the limited time available: administrative stays, additional briefing, amicus briefs, oral arguments, certiorari before judgment, and the like. On top of that, this court has 9 justices, each of whom can and does consult and deliberate with the other 8 to help the court determine the best answer, unlike a smaller 3-judge court of appeals panel or 1-judge district court. And this court also will have the benefit of the prior decisions in the case at hand from the Court of Appeals and the district court. Some might argue that preliminary disputes over the legality of major new statutes and executive actions can draw this court into difficult or controversial matters earlier than we might like, as distinct from what happens on our slower-moving merits docket. That is an understandable concern. But when it comes to the interim status of major new federal statutes and executive actions, it is often important, for reasons of clarity, stability, and uniformity, that this court be the decider. And members of the court have life tenure so that we can make tough calls without fear or favor. As with the merits docket, the court's role in resolving applications for interim relief is to neutrally referee each matter based on the relevant legal standard. Avoiding controversial or difficult decisions on those applications is neither feasible nor appropriate. Who is he writing to? What are we even talking? I don't know who's challenging. Like, you guys are the ones saying that I feel like you can't do this anymore. No, I don't. Okay, we'll get there, I guess. I don't know. We'll get there. Some might also worry that an early or rushed decision on an application could lock in the court's assessment of the merits and subtly deter the court from later making a different final decision. But in deciding applications for interim relief involving major new statutes or executive actions, we often have no choice but to make a preliminary assessment of likelihood of success on the merits. After all, in cases of that sort, the other relevant factors, irreparable harm and the equities, are often very weighty on both sides. Moreover, judges strive to make the correct decision based on current information, notwithstanding any previous assessment of the merits earlier in the litigation. It is not uncommon to think and decide differently when one knows more. This court has done so in the past. See West Virginia, blah, 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 1943 case, and undoubtedly will continue to do so in the future. To reiterate, this court should not insert itself into your mom into run-of-the-mill preliminary injunction cases where we are not likely to grant certiorari down the road, but determining the nationally uniform interim legal status for several years of, say, the Clean Power Act or Title IX regulations or mifepristone rules is a role that the American people appropriately expect this court, and not only the courts of appeals or district courts, to fulfill. I don't understand this at all. Okay. The volume of preliminary injunction and other enforcement litigation over new federal laws and executive actions coming to this court has been growing in recent years. That trend is in part the result of the increasing number of major new executive actions by recent presidential administrations of both political parties that have had difficulty passing significant new legislation through Congress. DGG or Kavanaugh. Based. Meanwhile, applications for stays or injunctions in capital punishment cases, election disputes, and other time-sensitive matters, including numerous COVID-19 related disputes in the few years beginning in 2020, have also continued to come to this court on a steady basis as they traditionally have. Although the volume of applications has increased, the court's responsibility for deciding consequential applications for stays or injunctions is not new. Yeah, we get it. You cited. Today's decision on district court injunctions will not affect this court's vitally important responsibility to resolve applications for stays or injunctions with respect to major new federal statutes and executive actions. Deciding those applications is not a distraction from our job. It is a critical part of our job. With that understanding, I join the court's opinion in full. Okay, I don't know what the fuck this other fucker doing. Okay. Good job. Good for you, buddy. Our dissent. We're almost halfway through. How the fuck long is this dissent? Jesus. Holy shit. Oh my God. Oh my Jesus. Okay. We're blog posting. Damn, she mad. Okay. Justice Sotomayor, with whom Justice Kagan and Justice Jackson join, dissenting. Children born in the United States and subject to its laws are United States citizens. That has been the legal rule since the founding, and it was the English rule well before then. This court once attempted to repudiate it, holding in Dred Scott v. Sanford that the children of enslaved black Americans were not citizens. To remedy that grievous error, the states passed in 1866 and Congress ratified in 1868 the 14th Amendment's Citizenship Clause, which enshrined birthright citizenship in the Constitution. There it has remained accepted and respected by Congress, by the executive, and by this court until today. It is now the president who attempts, in an executive order or citizenship order, to repudiate birthright citizenship. Every court to evaluate the order has deemed it patently unconstitutional and, for that reason, has enjoined the federal government from enforcing it. Undeterred, the government now asks this court to grant emergency relief, insisting that it will suffer irreparable harm unless it can deprive at least some children born in the United States of citizenship. C. Protecting the meaning and value of American citizenship. The government does not ask for complete stays of the injunctions, as it ordinarily does before this court. Why? The answer is obvious. To get such relief, the government would have to show that the order is likely constitutional, an impossible task in light of the Constitution's text, history, this court's precedents, federal law, and executive branch practice. So the government instead tries its hand at a different game. It asks this court to hold that, no matter how illegal a law or policy, courts can never simply tell the executive to stop enforcing it against anyone. Instead, the government says, it should be able to apply the citizenship order, whose legality it does not defend, to everyone except the plaintiffs who filed this lawsuit. The gamesmanship in this request is apparent, and the government makes no attempt to hide it. Yet, shamefully, this court plays along. A majority of this court decides that these applications of all cases provide the appropriate occasion to resolve the question of universal injunctions and end the centuries-old practice once and for all. In its rush to do so, the court disregards basic principles of equity as well as the long history of injunctive relief granted to non-parties. No right is safe in the new legal regime the court creates. Today, the threat is to birthright citizenship. Tomorrow, a different administration may try to seize firearms from law-abiding... Okay, hold on. Somebody's got to tell me this. How do you challenge an illegal action from the government and then get it busted? There must be a way or a thing that I'm missing. Is that always just an APA challenge? Is that what that looks like, or how does that work? Wait, somebody link me the The APA governs how federal agencies make rules on adjudications when impact litigation. Okay, what is an APA claim? In recent years, there's been an increasing amount of federal litigation involving immigration law initiated to challenge immigration law outside of immigration courts by filing a claim under the APA. Impact litigation of these claims are filed in federal district, not immigration court, which can level the playing field. Which types of APA? Okay. Wait, so then why didn't any of these people make an APA claim? Why were they all claims like this? Can somebody explain that to me? Jen, X, and Leon, you're both on the stand. Explain. Why weren't these APA claims or APA challenges? Can I Google that? Please have an answer. Why didn't APA challenge executive order? Oh, wait. It's an executive order. Can you APA claim? Wait, hold on. Can you challenge an executive order with APA claim? The AI says, yes, an executive order can be challenged using a claim under the Administrative Procedures Act. Specifically, the APA ensures administrative agencies, including those implementing executive orders, act within their authority. Wait, hamster hawk. Some of the lawsuits challenging Trump's policy have been brought under the APA. For instance, a district judge in Rhode Island issued a nationwide injunction against Trump's attempt to freeze vast amounts of federal spending after the judge found that the move would violate the APA, but not all policies or agency actions that would be subject to APA challenges. The birthright citizenship policy, for instance, was promulgated through an executive order, not through any federal agency. On the other hand, the order is a 30-day ramp-up period in which agency will develop. Okay, those guidelines might become targets for APA challenges. Okay, gotcha. Damn, all right. So you have to wait. Jesus. Okay. Sway time. Is there any good that will end from ending birthright citizenship? Yo, mama. No right is safe in the new legal regime the court creates. Today, the threat is to birthright citizenship. Tomorrow, a different administration may try to seize firearms from law-abiding citizens or prevent people of certain faiths from gathering to worship. The majority holds that, absent cumbersome class action litigation, courts cannot completely enjoin even such plainly unlawful policies unless doing so is necessary to afford the formal parties complete relief. That holding renders constitutional guarantees meaningful in name only for any individuals who are not parties to a lawsuit. Because I will not be complicit in so grave an attack on our system of law, I dissent. The majority ignores entirely whether the president's executive order is constitutional, instead focusing only on the question whether federal courts have the equitable authority to issue universal injunctions. Somebody says if a baby is dropped off at a fire station with no parent in sight, would that baby no longer be a citizen? I don't know. How do they do that in like European countries? Google it. The baby is now a firefighter. Baby based. Fuck, okay. The Citizenship Clause provides that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That means what it says. Nestled in the 14th Amendment, alongside the Equal Protection Clause, the Citizenship Clause does not discriminate on the basis of race, sex, ethnicity, religion, or, importantly here, parent age. It refers instead to all persons born or naturalized in the United States. Besides birth, there is only one condition, that one be subject to the jurisdiction of the United States. Yet that condition, too, leaves no room for ambiguity. To be subject to the jurisdiction of the United States means simply to be bound to its authority and its laws. Oh, she's going to spend a lot of time on this fighting on the merits, but the court is just ruling on the preliminary injunction part, basically. As the government would presumably concede, virtually everyone born in the United States and present in its territory is subject to its authority and its laws. After all, the jurisdiction of the nation within its own territory is necessarily exclusive and absolute. Once a citizen of another nation steps onto U.S. soil, she is, with narrow exception, amenable to the jurisdiction of the United States. That is why no plausible distinction with respect to 14th Amendment jurisdiction can be drawn between resident aliens whose entry into the United States was lawful and resident aliens whose entry was unlawful. Few constitutional questions can be answered by resort to the text of the Constitution alone, but this is one. The 14th Amendment guarantees birthright citizenship. Oh, parentage, not parent age. Oh, there's just a bad... Yeah, I didn't know what parent age... I didn't know if she was, like, snarkily referring to if you were older than the order or not. Okay. Oh, parentage. Yeah, you're right. My bad. That makes way more sense. Okay. The not father. Unsurprisingly, given the clarity of the Citizenship Clause's text, every other source of interpretation confirms this conclusion. Consider first its history. Long before the 14th Amendment, and indeed before the founding, the common law rule of jus soli, literally, right of the soil, governed English citizenship. That rule rendered a person's birthplace determinative of her citizenship status. Thus, the children of aliens born in England generally were natural-born subjects and entitled to all the privileges of such. Destiny. The merits matter because to get an injunction, you need to show a likelihood of success on the merits. It means the Supreme Court is giving this one to the government without them needing to show any harm at all. It's a real concern. Why are they granting it for this and not for a stronger case in favor of the government? Kind of zip. So they're playing a tricky game. They're not asking to get an injunction on the merits. They're asking whether or not these types of injunctions can exist at all, right? And that's what this court has ruled on. So they're avoiding the merits-based question and just asking about the merits of issuing a nationwide injunction, period, and not actually the merits of the injunctions themselves, right? Is the trick that the government has played, and I guess has won with. So, describing Calvin's case, which established that everyone born within the domain or the dominions of the King of England is entitled to enjoy all the rights and liberties of an Englishman. That English common law rule carried over to the United States after the founding. Shortly after the Constitution's ratification, James Madison observed that it was an established maxim that birth is criterion of allegiance, of citizenship, i.e., of citizenship. Birth, he explained, could convey citizenship in two ways, either through place, under the right of the soil principle, or through parentage, as for one born to United States citizens. But in general, Madison explained, place is the most certain criterion, and it is what applies in the United States. Mere decades later, Justice Story wrote that nothing is better settled than the doctrine that the children, even of aliens born in a country, are subjects by birth. Well before the 14th Amendment, then, it was the undisputed law of the United States that every person born within the dominion and allegiance of the United States, whatever were the situation of his parents, is a natural-born citizen. Though the law was clear, the nation did not always live up to its promise. Infamously, this court departed from the birthright citizenship principle in Dred Scott, holding that the children of enslaved black Americans are not included and were not intended to be included under the word citizens in the Constitution. Following the Civil War, the Reconstruction Congress corrected that grave error. Section 1 of the Civil Rights Act of 1866 declared that all persons born in the United States and not subject to any foreign power would be citizens of the United States. The 14th Amendment's guarantee of birthright citizenship followed 2 years later. The lawmakers who ratified the 14th Amendment understood that it would extend citizenship to all children born here, regardless of parental citizenship. Indeed, some objected to its passage on those grounds, complaining that it would permanently extend citizenship to immigrants who invade state borders and settle as trespassers. proponents agreed, if not with the anti-immigrant sentiment, that the clause would extend citizenship to the children of immigrants. For example, Senator Connis of California, one of the amendment's lead supporters, confirmed on the floor that the children born here of Mongolian parents shall be declared by the Constitution of the United States to be entitled to civil rights and to equal protection before the law. We have declared that by law, in the Civil Rights Act, he explained, and now it is proposed to incorporate the same provision in the fundamental instrument of the nation. Not one senator disagreed with this understanding of the clause. In the end, the citizenship clause was no legal innovation. Birthright citizenship is guaranteed by the 14th Amendment. The birthright is protected no less for children of undocumented persons than for descendants of Mayflower passengers. It simply restored the long-standing English common law doctrine of jus soli, abrogated by Dred Scott. The central purpose of the citizenship clause was, of course, to overrule Dred Scott. Following the ratification of the 14th Amendment, this court confirmed the amendment's plain meaning in United States v. Wong Kim Ark. At issue was the citizenship of Wong Kim Ark, a young California resident born in San Francisco to Chinese immigrant parents. When Wong returned to California from a trip to China, a customs collector denied him entry on the sole ground that he was not a citizen of the United States. This court held that the 14th Amendment affirms the ancient and fundamental rule of citizenship by birth within the territory. As the president does today, the government in Wong Kim Ark rested its case on the clause's sole qualifier. Wong was not subject to the jurisdiction of the United States, the government claimed, because at birth his parents were aliens in the United States who were subjects to of the Emperor of China, thus making Wong a subject of the Emperor of China as well. This court squarely rejected that attempt to limit the citizen clause's reach. Instead, it held the subject to the jurisdiction qualifier excludes only children born of alien enemies in a hostile occupation and children of diplomatic representatives of a foreign state, with the single additional exception of children of members of the Indian tribes owing direct allegiance to their several tribes. And then for the footnote, the first two exceptions had already been shown by the law of England and by our own law from the time of the first settlement of the English colonies in America to be recognized exceptions to the fundamental rule of citizenship by birth within the country. The additional exception for certain children born to Indian tribe members reflected the country's historical understanding that Indian tribes were quasi-foreign nations within the physical boundaries of the United States. That holding conclusively settled any remaining dispute over the citizenship clause's meaning. Since then, all three branches of government have unflinchingly adhered to it. This court, for one, has repeatedly reaffirmed Wong Kim Ark's holding. Notwithstanding legislation purporting to render Japanese persons ineligible for citizenship, we held in Morrison v. California that a child with Japanese parents is a citizen of the United States if he was born within the United States. The court recognized the same rule even during World War II, when individuals of Japanese ancestry were subject to curfew and exclusion orders. So, too, has the court recognized that the child of parents unlawfully present in the United States is, of course, an American citizen by birth. The same is true of children whose parents gained admission into the United States by unlawful means. Congress, for its part, has also reaffirmed the principles of birthright citizenship by enshrining it in a federal statute. Section 201 of the Nationality Act of 1940 provides that all those born in the United States and subject to the jurisdictions thereof shall be nationals and citizens of the United States at birth. The footnote, treaties between many tribes and the federal government at the time ensured that it was the tribe and not the U.S. government that had prescriptive and law enforcement authority over tribal members. Congress eventually extended birthright citizenship to tribal members born in the U.S. in 1924. See Indian citizenship in 1924. These exceptions are not at issue in these cases. For at least the last century, the executive branch has adhered to the same principle. When Congress proposed to reaffirm birthright citizenship in the 1940 Nationality Act, cabinet officials described it as a statement of the common law rule, which has been in the United States from the beginning of its existence. House Committee on Immigration and Naturalization, blah, 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 naturalization law, blah, blah. Indeed, the government concedes even now that the executive branch has recognized the vitality of birthright citizenship, at least back to World War II, if not earlier. That explains, among other things, why the Social Security Administration and the Department of State have long accepted proof of one's birthplace as proof of citizenship. Some decades ago, the Office of Legal Counsel was asked to respond to a House bill that would have denied birthright citizenship to children born in the United States to parents who are not citizens or permanent resident aliens. The answer well summed up the state of the law. This office grapples with many difficult and close issues of constitutional law. The lawfulness of this bill is not among them. This legislation is unquestionably unconstitutional. Undeterred by the Constitution, history, Supreme Court precedent, federal law, and long-standing executive branch practice, President Donald J. Trump issued Executive Order number 14160 on the day of his inauguration that purported to redefine American citizenship. The order declares that Destiny, after reading a bit more about this SCOTUS decision, do you still have hope and faith in our courts pushing back? The courts so far have done a good job. I don't know. This injunction thing seems silly, but I just don't. I wish I could. Are there any people who defend this ruling who have spoken about how are you supposed to stop a really bad executive order from taking place while it's being litigated? Are there any YouTube videos or people or writers or media people that have like spoken about that and given an opinion on that? The order declares that that U.S. citizenship does not extend to persons who are born to a mother unlawfully present in the United States or lawfully present on a temporary basis, and a father who is neither a citizen nor a lawful permanent resident. It further prohibits federal agencies from issuing citizenship documentation to such persons or accepting state documentation to that effect, and it directs a slew of federal officials to conform agency regulations to the order. The prohibition, according to the order, applies only to persons who are born within the United States after 30 days from the date of the order. Okay, I was confused about why she's referencing the birthright issue over the procedural issue, but I feel like I get what she's trying to say. I think she's arguing that the constitutional guarantee to birth certificate is so fundamental that procedural limits shouldn't stop the courts from enforcing controlling. Yeah, well, it's basically like saying, this is insanely hyperbolic, but it would be like saying the president passes an executive order saying that Donald Trump has the right to rape all children in the United States. And then there's an emergency, a temporary restraining order is issued from like 15 different courts because a whole bunch of different litigants, do a bunch of lawsuits, and then it gets up to the Supreme Court, and, like Trump is like out on the street, cock raging, Viagra coursing through his veins, ready to like rape a whole, he's like outside the daycare center. And then they go to oral arguments before the Supreme Court, and then the oral arguments are, the defendants, or not the defendants, the plaintiffs are like, hey, Trump is about to like rape all of our kids. It's like really fucked up. Can we not have this happen? And then the government is saying these temporary restraining orders that were issued, the person issuing the orders was actually doing it on a computer. And as far as we can tell, there's actually nothing rooted in the history of our country that says that issues ordered digitally are valid orders. And then the Supreme Court's like looking at this and they're like, oh, fuck. It all references like paper and bills and in the ordinary history and meaning. Like, did they ever really mean like digital stuff? Like, are zeros and ones actually? And then so the Supreme Court's like, well, we're going to go ahead and just stay this. We're going to say that like, we're not going to touch this issue right now about like the mass raping of the kids. Cause like, we're going to say that the orders need to be on paper. And it can't just be, via email and stuff. Like the digital stuff's not okay. And then good luck figuring it out. And I think that for the liberal side of the court, they're like, bro, this is like clearly and obviously fucking retarded. And the government's argument here, they're clearly avoiding the mass child rape argument because they just want to argue on some very silly procedural issue. While in reality, before the court is not only a very important question, but also a very obvious question, right? Obviously, the president can't issue an EO to go and mass rape children. We should probably address that right now rather than pretend that there's some huge question of constitutionality here and wait for that to get up to us through some other procedural process. I don't know why we're only addressing the digital. That's kind of what the argument is, which I feel like I kind of agree with that. Can the president of the United States really overturn birthright citizenship with an executive order? There's no way, right? Like that would just be crazy in my mind. And I mean, I think the fact that the government doesn't even try to defend that argument, I feel like that proves as much, right? True, MAGA did vote for it. Okay. Somebody said, I mean, in principle, doesn't this mean he is free to do so until the Supreme Court stops him? He's not about to. He can do it immediately. Well, for this EO, yes. In 30 days, birthright citizenship will be gone in the United States from every single person except for some of the listed plaintiffs in the lawsuit. That the birthright citizenship is going to be gone in 30 days, basically. Assuming it's 30 days from this ruling and not 30 days from the EO, in which case it's already gone. Yeah. Do you think the plaintiffs will try to establish a class and have the judge do an injunction based on that? Classes are, you would have to confer with Rule 23 and see, I don't know how to get, but I mean, the government also already said in oral arguments they would fight against class certification here. So here's the prerequisites according to Rule 23. A, in order to certify a class, the class is so numerous that joinder of all members is impracticable. That makes sense. There'd be a lot of litigants, so that's true. And then 2, there are questions of law or fact common to the class. That seems to be true. And then 3, the claims or defenses of the representative parties are typical of the claims or defenses of the class. I believe that's true. They're all fighting over the same thing, making the same claims. And 4, the representative parties will fairly and adequately protect the interests of the class. That seems to also be true. I don't know what they would even, actually, I don't even know what they would fight class certification on. I don't think they got into that specific of an argument. I don't even know. I have no fucking idea how they would even fight class certification on this. They just said they would. So I don't even know. There's already a new complaint issued with class action. Okay. All right. Maybe they'll get there, I guess. Okay. It's all right. We're over halfway done. We're on page 63 of 119. Good job, guys. The order declares that that United States citizenship does not extend to persons who are born to a mother unlawfully present in the U.S. or lawfully present on a temporary basis, and a father who is neither a citizen nor lawful permanent resident. It further prohibits federal agencies from issuing citizenship documentation to such persons or accepting state documentation to that effect, and it directs a slew of federal officials to conform agency regulations to the order. The prohibition, according to the order, applies only to persons who are born within the United States after 30 days from the date of the order. Shortly after the president issued the citizenship order, what is the goal? Why is she calling it citizenship order? Is that like a tongue-in-cheek thing, or is she being formal, or is that referencing some historical thing about this, or? Wait, the government addressed how they would oppose a station or a statewide class? Oh, did they? I don't remember that. Hold on.
Predicting that we will or will not oppose that. We haven't taken a position on that yet.
If you were to oppose it, on what basis would you plausibly oppose it?
There may be problems of commonality and typicality, for example. For example, there's two different sets of groups that are affected by the executive order. There are those where the mothers are temporarily present and those where the mother are illegally present. And in both cases, the father is neither a citizen nor a lawful permanent resident. So there might be issues of typicality. Adequacy of representation might very well be an issue. So there would have to be that rigorous application of those criteria. Now, the argument may be this is a case that is a natural candidate for a Rule 23b2 certification. That may well be true. The government hasn't taken a position on that. Our position is not that class certification will necessarily be granted. Our position is that Rule 23 is how these sorts of claims should be channeled.
And you
Gotcha. This podcast. All right, maybe I'll listen to this. We'll see. Oh, citizenship order is just the shorthand name of that particular EO. Okay. Shortly after the president issued the citizenship order, several groups of plaintiffs, together respondents, challenged the order in federal district courts in Maryland, Massachusetts, and Washington. Respondents include a group of pregnant women. Footnote, 2 of these women seek to represent a class of pregnant women and children residing in Washington state who are affected by the citizenship order. The district court has yet to rule on the certification of that putative class. Okay. A group of pregnant women whose children will not be U.S. citizens under the terms of the citizenship order. 2 immigrants' rights organizations with thousands of members across the country who are likely to give birth to children who would also be denied citizenship under the order, and 22 states, the District of Columbia, and the city of San Francisco. Nice. In their respective suits, respondents asserted that the citizenship order violates the 14th Amendment and Section 1401, subsection A. Respondents also sought a preliminary injunction barring enforcement of the citizenship order during the pendency of the litigation. If allowed to go into effect, they said, the policy would inflict irreparable harm on their children and their members' children by denying them enjoyment of the full privileges, rights, and benefits that come with U.S. citizenship and rendering them vulnerable to unlawful deportation before the courts could adjudicate their constitutional claim. As for the states, they attested that enforcement of the citizenship order would cost them millions of dollars in federal funding and impose significant administrative burdens. The states administer numerous programs for the benefit of their residents, including for newborns and young children, some of whom are wards of the plaintiff states who are entitled to care by statute. Those social welfare programs include ones provided for by state law, as well as ones established by federal law, such as Medicaid and the Children's Health Insurance Program. Several of them are funded in part by federal dollars, with federal funding frequently tied to the citizenship and immigration status of the individuals served. By stripping some children
base?
within the states of their citizenship, the order would reduce the state's federal funding, forcing the states to bear significantly increased costs to operate and fund programs that ensure the health and well-being of their residents. Relatedly, because the states must verify the citizenship status of the individuals they serve, the states alleged that the citizenship order would force them to expend significant sums to modify their operational structures and administration to account for the changes in citizenship. All 3 district courts preliminarily enjoined enforcement of the citizenship order. Each court determined that the citizenship order was likely unlawful, that respondents were likely to face irreparable harm without an injunction, and that the equities and public interests cut decisively in respondents' favor. The district courts further determined that only injunctions blocking the citizenship order's enforcement nationwide would completely redress respondents' injuries. For the organizational plaintiffs, the Maryland District Court explained that those plaintiffs have over 680,000 members who reside in all 50 U.S. states, and hundreds of them expect to give birth soon. The Washington District Court found that a geographically limited injunction would be ineffective for the state plaintiffs, as it would not completely relieve the states of the order's financial burdens. For one thing, that court explained, the constant flow of people moving in and out of various states meant some children born to non-citizen parents in a non-plaintiff state would later reside in a plaintiff state. Once there, those children under state law would be eligible for state benefits, yet due to the citizenship order, the plaintiff states would no longer receive federal funding to support those benefits. In addition, the plaintiff state would have to create an entirely new administrative and record-keeping system to accommodate children who were not citizens under the order and born in a non-plaintiff state. So if the district court allowed birthright citizenship to continue for children born in the plaintiff states, but not in any other state, that would not completely redress the state's financial injury. For identical reasons, the Massachusetts District Court also found that the state plaintiff's injuries could be redressed only by a universal injunction. The government filed motions to stay the injunctions in 3 separate courts of appeals. Nowhere did the government contest the district court's uniform holdings that the citizenship order likely violated the Constitution. Instead, it challenged only the scope of the ordered relief, arguing that the injunctions should be narrowed to block the order's enforcement against only the individual persons named in the complaints. All 3 appellate courts denied the government's request and left the preliminary injunctions intact. The Fourth Circuit, which reviewed the preliminary injunctions issued to the organizational plaintiffs, concluded that the district court carefully explained why an injunction limited to the parties, including organizations with hundreds of thousands of members nationwide, would be unworkable in practice and thus failed to provide complete relief to the plaintiffs. The First and Ninth Circuits left undisturbed the Massachusetts and Washington district courts' respective determinations that only universal injunctions would fully redress the state's injuries. On March 13th, the government filed emergency applications with this court requesting partial stays of the 3 preliminary injunctions of the citizenship order. The government renews its contention that the injunctions must be narrowed to benefit only formal parties in these cases. In partially granting the government's remarkable request, the court distorts well-established equitable principles several times over. A stay, this court has said, is not a matter of right, but rather an exercise of judicial discretion. Wait. Blah, 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 blah. I feel like the majority of her thing here is going to be on the merits of the case, which the rest of this didn't really talk about, so I don't know how relevant it'll be. But maybe there's other people we can listen talking about this. I'll just read the rest of this on stream. Maybe, we'll see. I'm ordering food, though. When it gets here, I'll stop. In partially granting the government's remarkable request, the court distorts well-established equitable principles several times over. A stay, this court has said, is not a matter of right, but rather an exercise of judicial discretion. For centuries, courts have closed the doors of equity to those tainted with inequitableness or bad faith relative to the matter in which they seek relief. Yet the majority throws the doors of equity open to the government in a case where it seeks to undo a fundamental and clearly established constitutional right. The citizenship order's patent unlawfulness is reason enough to deny the government's applications. The government also falls well short of satisfying its burden to show that it will likely suffer irreparable harm absent a stay, and that it will likely succeed on the merits of its challenge to the scope of the injunctions. The executive branch has respected birthright citizenship for well over a century, and it advances no plausible reason why maintaining the status quo while the litigation proceeds would cause it irrevocable harm. Nor could it, for the Constitution of federal law, prohibit the enforcement of the citizenship order. I don't understand the irrevocable harm argument. It seems like they're giving like a per se status, saying that every single time the government is prevented from enforcing any law ever, it's irreparably harmed. That feels like I don't know, that feels really silly to me. I don't understand that. I feel like you should have to make the argument there. But for all that, moreover, the government is not even correct on the merits of universal injunctions. To the contrary, universal injunctions are consistent with long-established principles of equity, once respected by this court. What is more, these cases do not even squarely present the legality of universal injunctions. That is because, even if the majority were right, then injunctions can only offer complete relief to the plaintiffs before the court. Each of the lower courts here correctly determined that the nationwide relief they issued was necessary to remedy respondents' injuries completely. So even ignoring the traditional stay factors and accepting the majority's view of the merits, there is no reason to grant relief in these cases. Do we know in what way Congress can amend the law to allow district courts to issue more temporary relief orders against unlawful executive orders while litigating? I don't know if you could. I would have to reread. I would have to look at the Constitution in regards to what the judiciary is granted, because I kind of feel like the arguments against I guess the universal injunctions were pretty strong. I never heard any of it before. I felt like it was really stupid when I listened to this a couple months ago, but I feel like the arguments are decently strong. But that's not that's not the question before this court right now. It shouldn't be, at least. That's such a stupid red herring. But I don't know if the Congress would have the authority to grant that power to the courts, because what they're basically asking is to grant the power to a court to provide for the court to provide relief for members that are not parties to a case. It's just it's procedural stuff, but it's meaningful. I don't know. Jesus. Okay. It is a bedrock principle that parties who request a stay must show that they will likely suffer irreparable harm absent such relief. Indeed, the authority to grant stays has historically been justified by the perceived need to prevent irreparable injury to the parties or to the public pending review. Thus, an apparent likelihood of success on the merits never suffices on its own to justify this court's intervention. Our emergency docket is not a mechanism for an expedited appeal. Accordingly, this court can avoid delving into the merits if the applicant does not demonstrate an irreparable injury. Citing Kavanaugh. Good job. What grave harm? I don't understand this. This is, I think, one of the strongest arguments here. This is ridiculous. What grave harm does the executive face that prompts a majority of this court to grant it relief? The answer, the government says, is the inability to enforce the citizenship order against non-parties. For the majority, that answer suffices. When a federal court enters a universal injunction against the government, it improperly intrudes on a coordinate branch of the government and prevents the government from enforcing its policies against non-parties. The problem, however, is that the executive branch has no right to enforce the citizenship order against anyone. As the executive itself once put it, the order is unquestionably unconstitutional. It defies logic to say that maintaining a centuries-long status quo for a few months longer will irreparably injure the government. That right there, yeah. The purpose of equitable relief is merely to preserve the relative positions of the parties until a trial on the merits can be held. Like, preliminary relief is basically like, okay, hold on. Like, imagine you're talking to some friends and one guy has a knife and he's slowly about to cut his friend's throat, and the other guy is like trying to prevent it, and then both of them appeal to a judge, and like one of them is saying like, hold on, before we rule whether or not this guy can fucking stab me in the throat, okay, we've been friends for like 10 years, but he wants to cut my throat, okay, can we like get like a stay here? Okay, can we just like chill until like we finish our court case, you know, to figure out if he could stab me in the throat or not? And then like imagine the friend being like, well, I feel like if he's not allowed to stab you in the throat, we're irreparably harming his right to stab you. And it's like, okay, well, let's assume he doesn't stab me and then he wins his case against me and then he's allowed to stab me. I mean, it's basically the same shit for him, right? For me, though, it's kind of important to not have my throat stabbed right now, right? Like, the irreparable injury is way more on my side than on his side. I don't understand how they get to the government's argument of saying they will suffer irreparable harm if they're not allowed to enact this executive order right the fuck now. Like, the executive order was passed 5 months ago. Has the government been harmed? We've had this view of birthright citizenship for over a century. Has the government been irreparably harmed that they have to go a few months later? Like, it just doesn't make any sense. Other than a per se understanding saying that anytime another branch of government abridges or enjoins the executive's ability to enforce some executive order, even not even like a rule from a federal agency and not a new law from Congress, anytime they're enjoined from that, they're being irreparably harmed. That's enjoined by now. That's wild. I don't know. I don't buy that. That just seems silly to me. Let me use the restroom real quick. 1 sec. Oh, this person wants me to join. Okay. The majority claims they can sidestep analysis of the executive order altogether because, in its view, every overbroad injunction necessarily causes irreparable harm sufficient to warrant emergency intervention. Yet, where a purportedly overbroad injunction orders the government to do only what the court has expressly held it is required to do, it is hard to see how it could cause any harm. At oral argument, the government conceded it was bound to follow this court's precedent. This court's precedent establishes beyond a shade of doubt that the executive order is unconstitutional. Thus, by enjoining the government from violating settled law, the district court's order did not cause the government any harm. The majority's contrary position is self-refuting. Suppose an executive order barred women from receiving unemployment benefits or black citizens from voting. Is the government irreparably harmed and entitled to emergency relief by a district court universally enjoining such policies? The majority apparently would say yes. Nothing in this court's precedents supports that result. It turns one of the most critical factors we must consider in deciding whether to grant a stay into a box-checking exercise whenever the relevant enjoined action is an executive one. Even accepting that any time a state is enjoined by a court from effectuating statutes enacted by representatives of its people, it suffers a form of irreparable injury. That democratic consideration cuts against the government in these cases. Oh, thank you. Yes, this is what I was bringing up. They cited that, and I'm like, bro, that's when you're blocking a law passed by like a Congress. It's not even remotely so. This is an executive order. The fuck? How could you compare these? But okay. Through the ratification of the 14th Amendment, Congress and the states constitutionalized birthright citizenship. Congress also codified birthright citizenship in Section 1401, subsection A. It is thus the citizenship order, not the district court's injunctions, that prevents the effectuation of a constitutional amendment and repeals a statute enacted by representatives of the American people. Simply put, it strains credulity to treat the executive branch as irreparably harmed by injunctions that direct it to continue following settled law. All the officers of the government, from the highest to the lowest, are creatures of the law and are bound by it. Well, that's not true anymore, apparently. Oh, true. Wait, right? Citing United States v. Lee, but see Trump v. United States. Good one. That's a good one. That's a good one. We stand. The injunctions do more harm to the executive. I'm sorry. The injunctions. Stop! I'm trying to. Okay. The injunctions do no more harm. No, stop! The injunctions do. No, that is correct. The injunctions do no more harm to the executive than the Constitution and federal law do. A majority of this court, nonetheless, rushes to address the merits of the government's applications, holding that universal injunctions likely exceed the equitable authority that Congress has granted to federal courts. A majority that has repeatedly pledged its fealty to history and tradition thus eliminates an equitable power firmly grounded in centuries of equitable principles and practice. By stripping all federal courts, including itself, of that power, the court kneecaps the judiciary's authority to stop the executive from enforcing even the most unconstitutional policies. That runs directly counter to the point of equity, empowering courts to do complete justice, including through flexible remedies that have historically benefited parties and non-parties alike. A brief recounting of equity's history demonstrates the majority's grave error. The American legal system grew out of English law, which had two primary judicial institutions, the common law courts and equity courts. Equity courts arose because of the inflexibility of the common law system. Their purpose was to look beyond formal writs and provide remedies where the common law gave inadequate relief. In Blackstone's words, equity was meant to give a remedy in cases where none before was administered. Adaptability has always been a hallmark of equity, especially with regard to the scope of its remedies. While common law courts were compelled to limit their inquiry to the very parties in the litigation before them, equity courts could adjust the rights of all, however numerous, and adapt their decrees to all the varieties of circumstances which may arise, and adjust them to all the peculiar rights of all the parties in interest. After all, equity's constant aim was to do complete justice. Accordingly, equity courts could decide upon and settle the rights of all persons interested in the subject matter of the suit, so that the performance of the decree of the court may be perfectly safe to those who are compelled to obey it, and also that future litigation may be prevented. For equity courts, injunctions were manifestly indispensable for the purposes of social justice in a great variety of cases. Unlike this court, then, those courts constantly declined to lay down any rule which shall limit their power and discretion as to the particular cases in which such injunctions shall be granted or withheld. Justice Story underscored the wisdom in this course. Equity courts needed flexibility to craft injunctions for particular cases, as it was impossible to foresee all the exigencies of society which may require their aid and assistance to protect rights or redress wrongs. In their pursuit of complete justice, equity courts could award injunctive and other equitable relief to parties and non-parties alike. For centuries, they did so through what was known as bills of peace. If a plaintiff or a group of plaintiffs filed such a bill, an English court could use a single case to settle disputes affecting whole communities, for the inherent jurisdiction of equity included the power to interfere for the prevention of a multiplicity of suits. Bills of peace issued in cases where the parties were very numerous and the court perceived that it would be almost impossible to bring them all before the court, or where the question is of general interest and a few may sue for the benefit of the whole. In such cases, a court could grant equitable relief without making other persons parties, instead considering them quasi-parties to the record, at least for the purpose of taking the benefit of the decree and of entitling themselves to other equitable relief if their rights were jeopardized. Early American courts embraced bills of peace and extended their logic to cases which were not technically bills of peace but were analogous to or within the principle of such bills. One example was taxpayer suits, which allowed courts to enjoin universally the enforcement of a challenged tax. Sometimes such suits were filed by any number of taxpayers, such as co-plaintiffs, or by one taxpayer suing on behalf of himself and all others similarly situated. But taxpayer suits were not always representative in nature. Even a single taxpayer suing on his own account, if victorious, could enjoin the collection of a tax against anyone. Individual plaintiffs, moreover, could secure an order to set aside and annul any and every illegal public official action whereby a debt would be unlawfully created. By allowing complete and final relief to be given to an entire community by means of one judicial decree, American courts, like their English counterparts, spared non-parties and themselves from the burden of an indefinite amount of separate litigation. Federal courts have also exercised equitable authority to enjoin universally federal and state laws for more than a century. For instance, before deciding the constitutionality of a new federal law in Lewis Publishing Company v. Morgan, this court entered an order blocking the law's enforcement against parties and non-parties. In Lewis, two newspaper publishers challenged as unconstitutional a federal law requiring publishers to file with the Postmaster General twice yearly disclosures about their editorial board membership, corporate ownership, and subscribership. After the district court upheld the law and authorized a direct appeal to the Supreme Court, one of the publishers moved for a restraining order. The proposed order sought relief not only for the publisher who filed it, but asked the court to restrain the Postmaster General and other federal officials from enforcing the law against appellant and other newspaper publishers. This court readily agreed, even as it would have sufficed for the movement publishers' sake to enjoin the act's enforcement against them alone, pending their appeals. Okay. Oh, fuck, that's a lot of reading. Okay, I don't know if I'll read the rest of this on stream or off stream. I'm going to eat real quick, then I'm going to do some more toking, I think. Stop. I don't agree with the ruling, but wouldn't irreparable harm in this case simply be that some people would be granted citizenship in the meantime? Yeah, but that's the status quo, bro. Irreparable harm, I don't think is usually like about like preserving the status quo. Like usually stays and stuff are for the status quo. The idea that you would issue a stay to block an injunction in order to severely disrupt the status quo, and then you would cite irreparable injury as the rationale for issuing the stay is like, is mind-bogglingly weird. Can you give a summary so far? Nope. It's complicated legal procedure bullshit, cringe shit. It's cringe. Basically, it's cringe. Basically, what happened was Trump issued an executive order getting rid of birthright citizenship. A bunch of courts said this is fucking retarded. And then the Supreme Court is saying, well, they can't tell them that it's retarded for everybody. So only the 3 people that sued can say it's retarded, and everybody else will figure it out later, I guess, which is retarded. Is the insane procedure a tell that the court will overturn birthright citizenship? I mean, I don't think so. There was nothing in any of the majority ruling that gave any indication. Wait, fuck, stop. Hi.